Mr. President, judges of the Caribbean Court of Justice.
Please, sir.
The Caribbean Court of Justice, Appellate Jurisdiction. On appeal from the Court of Appeal of Guyana, the hearing of the appeal in the matter GYCV2023-005 between Ramon Gaskin and Minister of Natural Resources and Exxon Mobil Guyana Limited, CNOOC Nexen Petroleum Guyana Limited, Hess Guyana Exploration and Environmental Protection Agency. The members of the hearing panel are the Honorable Mr. Justice Saunders, President and Presiding Judge, the Honorable Mr. Justice Anderson, the Honorable Madam Justice Rajnath Lee, the Honorable Mr. Justice Barrow, and the Honorable Mr. Justice Burgess. Counsel, you may now enter your appearances.
Yes.
President, Honorable Judges of the Justice. My name is Edward Lapu, Senior Counsel. I appear for the respondent, Minister of Natural Resources. Associated with me are Ms. Deborah Umar, Deputy Solicitor General, and Ms. Eleanor Lapu. Thank you.
Yes, thank you.
May it please your honors. I am Andrew Pollard, Senior Counsel. I appear for the added respondents, Exxon Mobil Guyana Limited, CNOOC Petroleum Guyana Limited, and Hess Guyana Exploration Limited. Appearing with me is Mr. Nigel Hughes, who has joined remotely, your honors.
Yes, and we've seen him online.
Good morning, Your Honors. I am Sandeep Gaskin. I appear for the Environmental Protection Agency, amicus curiae party, and with me is Ms. Francis Harris.
Yes. Yes. Thank you all for your appearances. Good morning, everyone. Mr. Jairam, are you ready?
Your Honors, I take it that the various respective submissions have been read. I don't propose, therefore, to utilize the time allotted to me to rehash or repeat, except if there is something that I need to emphasize
So, John, may I say that you have immediately endeared yourself to me? Thank you.
I am much obliged, Your Honors. I'm glad we're on the same, singing from the same hymn sheet. I would like to say, however,
Go so far.
I would like to say that in the Commonwealth Caribbean, the Cooperative Republic of Guyana, together with Jamaica to some extent, has a unique and interesting constitution, first enacted as Act Number 2 of 1980. But the relevant amendment appeared to have been made in 2003, according to the marginal/side note. Like all other written constitutions, as we know, Article 8 of that constitution makes the constitution the supreme law of Guyana, and it has the pro tanto void provision. Interestingly, Your Honors, I draw to your attention Article 149, capital G thereof. And it places issues touching and concerning the environment at the very top of the mountain. And that article, if I may tarry you, 149, capital G, sub-article 1, everyone has the right to an environment that is not harmful to his or her health or well-being. 2, the state shall protect the environment for the benefit of present and future generations through reasonable legislative and other measures designed to A, prevent pollution and ecological degradation, B, promote conservation, and C, secure sustainable development and use of natural resources while promoting justifiable and economic development. Therefore, I ask this apex court that any laws touching and concerning the environment must be seen through Guyana's constitutional lens, which places supremacy of the environment. And not only Article 149G, but in tandem with 149G are Articles 25 and 36. 25 reads, every citizen has a duty to participate in activities designed to improve the environment and protect the health of the nation. And may I pause there? So if you have a public-spirited Guyanese wishes to challenge what is taking place on the ground, he is to be applauded and not to be condemned, as is the want of the executive, it would appear, according to public records. 36, the well-being of the nation depends upon the preserving clean air, fertile soils, pure water, and the rich diversity of plants, animals, and ecosystems. So I respectfully submit, Your Honor, against that background, the court, we urge to view and interpret and apply the Environmental Protection Act with the supremacy or priority against all other laws. I ask you to note, because it seems to be, not it seems, it is a point in contention. I ask you to note, for completeness, the Environmental Protection Act was passed in 1996. Whereas the Petroleum Exploration and Protection Act, Chapter 6504, was passed in 1986, some 10 years before. Your Honors, I think, and if I may rely on there's at least one decision of this honorable court reported in the law reports of the Commonwealth LRC is the cases of GGMC and BK International, Volume 2, law reports of the Commonwealth at page 491. I'm not intending to, but just to Mr. Justice Anderson gave the leading judgment, and His Honor, if I may leave it with you, the reference at paragraph 19 alluded to how the courts ought to approach Caribbean-speaking constitutions. And then Mr. Justice Witt, who unfortunately is no longer with us, especially his judgment starts at paragraph 53, but the relevant paragraphs for our purposes is 54, 55, and 56. Do you,
Counsel,
sorry,
could you please just remind me of the paragraph?
I'm so sorry.
in
I said
respect of Justice
Mr. Justice Witt's judgments.
Anderson.
Anderson. Oh, I am much obliged. Sorry. It's paragraph 19.
19, thank you very much.
19. And Mr. Justice Witt. In particular, paragraphs 54, 55, and 56. Would you like me to read that, or I could take it, I pass on? And Mr. Justice Jamadar, too, also has very interesting observations to make. And the particular paragraphs are 63 to 65. And in essence, Your Honors, I'm heartened by the approach of this apex court. And although Trinidad and Tobago and Jamaica haven't joined, I think the jurisprudence would lend to judicial review in the respective jurisdiction. You have to see it through the lens of our written constitution, not the supremacy of Parliament. Supremacy of Parliament is an unwritten constitution. Supremacy of Parliament is only supreme within the confines of your written constitution. So where Guyana has put the environmental issues at the very top of the mountain, you ought to give some, may I say some, well, to give some positive interpretation and application over and above all other ordinary laws.
Mr. Jarab, I take it that you will apply what you're saying to us to this case, because I'm just here very happy about the Constitution of Guyana.
Yes,
Because I think it's probably the most advanced in the Caribbean.
I think so
Well
too.
before its time.
Yes.
But at the same time, how does that help us in how we interpret the relevant sections and what is before us? I think that is what we would want from you.
Well, because the Constitution makes it part of the supreme law, matters touching and concerning the environment, I ask you, when you come to interpret the Environmental Protection Act, Chapter 2005, to interpret it in such a way to harmonize with the Constitution.
No, I'm just wondering, is the environment in Guyana more adversely impacted because of what was done by the minister? I thought that is where you would take us, to say that is why the Constitution was so careful to guard the environment. But I'm
Well, we are saying-
also, as you address us, you could tie it in, because just to leave it hanging is not,
Yes.
in my humble submission, helping us.
Very well. You can't do environmental act. May I take you to the environmental act right away, please? At page 7, I ask you to note the long title of that act. An act to provide for the management, conservation, protection, and improvement of the environment, prevention and control of pollution, the assessment of impact of economic development on the environment, the sustainable use of natural resources and for matters, etc. The definition section 2, I will just leave reference with you, Your Honors. Adverse effect. Now, I ask you to note on page 8, the agency, of course, is the EPA for short, but development consent, the definition, means the decision of the public authority which entitles the developer to proceed with the project. Now,
Sir, but before you go there, I was wondering if, in response to my sister, you would have thought citing some of the principles to be applied under the EPA may not be relevant. And the one I have in mind particularly is a precautionary principle. Would that help you to descend from the lofty clouds of the environmental norms to something more concrete?
Your Honor, the section,
Maybe section 4, from recollection, but
section 4 of the Environmental Act at page 11. The functions of the agency are A, to take such steps as are necessary for the effective management of the natural environment so as to ensure preservation, protection, and sustainable use of its natural resources. So the sole authority, I would say, at law, which has a constitutional protection, is the EPA. Nobody else is authorized to take any action with respect to the environment. Not the executive, not the minister, not anybody else, the EPA.
yes, Counsel, I'm not hoping for you to rely on my memory because it goes back some distance and sometimes it's reliable and other times it may not be. But I seem to recall that there is a provision in the Act which requires application of certain
That's subsection
accepted
4, please, Your Honor.
environmental principles, such as the precautionary principle.
Yes. Subsection 4 of that section at page 16
Yes.
says, in performing its function, the agency shall make use of the current principles of environmental management, namely, A, the polluter pays principle. In other words, if you're polluting, and that's an important aspect, because this case has to do with 3 separate and distinct entities. I'll call them short, either SO or Exxon, same thing, same khaki pants. And then we have HES and CNOC. So if the other two are piggybacking, is the expression I used in the course below, on SO, and they are the polluter, it means that they're escaping that principle, because only the EPA can enforce a permit granted by the EPA. It has conditions and implied conditions. And if I will just, before I move on, Your Honor, just to paint that scenario, section 13, I'll come back to where I stopped. A decision, as at page 27, a decision by the agency to issue an environmental permit for a project. And Your Honors, a lot of weather has been made of a project. And an environmental permit does not exist in space or in vacuum. I would say that's surplusage, because a permit is in respect of a project, any project. And a project has a very wide English definition in the dictionary. Could mean anything. And when you check with the 4th schedule, but the project under the 4th schedule or any other project. Even building a hotel with 10 rooms or more, you have to get, shall be subject to conditions which are reasonably necessary to protect human health and the environment, and each environment permit shall contain the following implied conditions. So it is the issuance of an environmental permit that the EPA can latch on to enforce those who interfere with the environment, cause damage or degradation, and a number of implied conditions are there. So coming back where I stopped, Justice Anderson. A is the polluter pays principle, B is the precautionary principle, C the strict liability, D the avoidance principle, and E the state of technology.
Right. So, sorry, if and I don't mean to detain you too long on this, but if you could just draw a line here, because I just wanted to get some clarity as to how you're relating the principles in the Constitution to the facts here. And those constitutional principles, you could say, are mediated through, the environmental principles in the Act.
Yes.
Okay, so one of the main principles is the precautionary principle, which says that basically if you are in doubt as to whether an activity is going to cause harm to the environment,
Yeah.
you must err in favor of protecting the environment.
Precisely.
Would you agree?
Yes.
Okay, so that is one, and then the other one that seems also quite useful is the state of technology principle, that you should use the best technology feasible
Yes.
in conducting activities
Yeah.
to reduce adverse impacts on the environment. Would you also agree?
Yes.
Okay, so precautionary and maybe state of technology are two of the principles which will help to reduce the abstract nature of the constitutional arrangements.
Exactly.
Okay, thank you. Thank you very much.
And that is why we say, according when you read this act, and our submissions, although we didn't have that authority in the courts below, Midland Scrap Metal and the Irish EPA, that case is very useful and makes it clear that before I go through and says this, the Waste Disposal Act in Ireland didn't have a specific provision, and they said from the judges, both in first instance and the Court of Appeal, have made the point that from the scheme, purpose, and intent of the Act, it's very clear that anybody, and we say on a plain reading of the Environmental Protection Act, everyone. The short point is, SO had permit under the Environmental Protection Act, and SO was entitled to development consent, SO by itself. But two other entities or two other persons or two other whatever cannot come under the umbrella of SO. They have to each or together apply for a permit. And only then when you get the permit, and Your Honors, that the minister was alive to it.
Counsel,
Sorry?
if I may, Counsel.
Yeah.
Is it stated in the act that the others must also apply?
No. But what I'm saying, when you look at this,
How do we get?
when you look at the scheme and purpose of the act and what the Constitution says, you must interpret the provisions of the act purposes to give some effect and purpose to it. I said the minister was alive to it. May I just... The first... Well, I ask you to bear in mind, our judicial review is against the minister. The others apply to join. We didn't think that we had any business in the judicial review against SOS and the EPA, I think, came into as a makers. This is the petroleum agreement between the government and SO and the other two. It's dated the 6th of June, and that could be found at page 38 of 540. At page 226 of that agreement, lower down the page, the word contractor is defined. Contractor means SO, Nexon, and HES, and includes their successors and permitted assigned. Now, interestingly, Your Honors, the minister had it quite right, it would appear, when he issued this permit, but he seemed to have allowed himself to fall in error. And that is reinforced at page 285 under clause 28.1.1. And may I read it because it's important. In accordance with the Environmental Protection Act 1996, the contractor, and the contractor singular include plural and vice versa. The contractor comprises three entities. The contractor shall obtain an environmental authorization as required from the Environmental Protection Act. From the Environmental Protection Agency, and comply with the provisions of the Environmental Protection Act in relation to any activity of this agreement that is governed by the Environmental Protection Act. As the name suggests, the agreement, we all know that petroleum and petroleum activities have the potential to interfere or damage the environment. World is littered with recent examples. It is self-evident truth. So you have to take precaution to ensure. And all we are asking, and I told the learned Chief Justice when I opened this case 6 years ago, I said we are not about stymieing Guyana's earning revenue. What we are about is that multinationals must obey the laws of the land. That's all we are asking. And they're not obeying the laws of the land.
Yeah, Counsel, I think I would like to sort of take you back to the question asked by my sister, because I think that is central.
Yes.
The question is, in what way are the objectives of the EPA being frustrated by the grant of the PPL to the three parties
Yes.
to which it was granted, rather than to ESSO alone?
Right.
Because it seems to me, certainly from reading the documents, that it is ESSO that is the operator
Yes.
of the project.
Well, there's no evidence of that. They're simply saying operator.
I thought that was in the agreement.
But remember, Your Honor, remember, please, the development consent is the PPL.
Yes.
So once you issue a PPL to Tom, Dick, and Harry Lally, if I may use that expression, you have development consent, so you could proceed, you could operate. That is the problem. There is no affidavit evidence. Is minister given label to these arrangements and calling them contractor, but we can only, there is no affidavit evidence that only ESSO carries out operation.
I accept for the moment that point. And we could get back to it. Let us assume, however, just for the argument, that it is only ESSO who can carry on this project,
Yes.
the operational aspects of this project. And in fairness, I think they are described as such in the agreement, certainly. Would you agree then that it is only ESSO, since they're the only ones who are carrying operational aspects of the program forward, who could give a guarantee of, for example, the use of the state of technology? And who could give a guarantee as to the implementation of the precautionary principle? Since they are the only ones who are carrying on the operational aspects of the project that can impact adversely on the environment.
Assuming, but not admitting,
Yes.
they are the operator. The EPA, having granted a permit to ESSO, can only compel ESSO and no one else.
Yes.
Because it has not granted a permit to anyone
Agreed.
else.
Agreed.
But the PPL, where it collides with the EPA, is that it purports to give development consent. So if they don't need it, let's have it. Now, at the court below, Your Honors, I had argued to quash the entire PPL. But I thought about it, and Guyana's changed the regime in the new Petroleum Act, and I think it has some waiting period, publication, and so on. We don't want to interfere with that. I will say, if you agree with me, at the end of the day, there'll be a severance.
But is there another way of getting at the same result? Because
What's that, Mario?
I'm raising it with you for your consideration. If what you're saying, arguendo, is the case, and only ESSO has been granted an environmental authorization to conduct the project, so the drilling, the emissions, the rehabilitation of the land that is polluted, etc., only ESSO has an obligation in respect of those matters. If either of the other two parties was to attempt to conduct any of those activities, would they not be breaking the law? Would they not be exposed to criminal sanctions by the law?
Well, right now they're exposed to criminal sanctions because they have a PPL to proceed with the project. We don't know.
No, no,
we don't
no,
know
no, no,
what
no,
they are doing.
no, sorry, with respect, I'm not, I'm saying that if it is shown
Yes, of
that
course.
either of the two
Yes.
would have done operational matters connected to the project, then ipso facto, they would be exposed to criminal penalties, would they not be?
Of course, Your Honor. Anybody who degrades the environment or has anything to do to harm the environment
Without a permit?
without a permit is exposed to criminal and, well, you could say sanctions, fines, and or
So
imprisonment.
if you agree with that, then I'm still grappling with the question asked by my sister. I'm trying to understand, therefore, what is the heart of the concern that you have. Because if I could summarize, you are saying that SO can go ahead and conduct the project
Yes,
in accordance with the environmental permit.
yeah.
The SO company, if you will, has many obligations, as we know, under the environmental permit, and must conduct activities consistent with those obligations. You're saying further that nobody else can lawfully undertake those operational aspects.
Yes,
If they were to attempt to do so, they would be breaking the criminal law of the Republic of Guyana
yes,
and exposed to criminal penalties.
yes.
So does not answer your concern, is what I'm trying to get from you.
No, Your Honor.
Yes.
One must be practical.
If I may, in reading your written submissions, I was getting the impression that what you were saying is that the agency, the Environmental Protection Agency, has no jurisdiction whatsoever because it didn't issue the environmental permit to the two added respondents.
Yes.
It has no way of investigating or looking into what they're doing.
Precisely.
Am I right in reading your?
We stand by that. But to answer your brother, Mr. Justice Anderson, let's be practical and pragmatic about it. They have this provision from the Petroleum Act, I call it for short, about joint and several obligations. You can have a cat and mouse game, Your Honor. If something were to happen, exercise, well, it's not me. It's Hess or CNOC.
No, but if the documents clearly state that liability for harm is joint and several, how is it possible that any one of the parties could say, I am not liable, the other is?
That's a contractual thing amongst them, Your Honor.
No, it's not only among them. It is as between them and the other side of the contracting party,
The government.
Well,
government.
remember, enforceability is vested in the agency, EPA, and it doesn't delegate it to any minister or any prime minister or any president. So whatever they have, if it concerns the environment, we say that was never the intention of the Environmental Protection Act, to bring in somebody. Apply for, produce an environmental impact assessment. Let the EPA assess your financial suitability and antecedents and so on.
But you said that they should have CNOC and Hess should have sought a permit themselves.
Yes. Either together with SO
And
or,
that
or
permit would have
individually.
required an environmental impact assessment.
Yes.
Isn't what was going to be assessed identical to what had previously been assessed in relation to ExxonMobil?
Not really, Your Honor. Not really. There are additional things the EPA has to be satisfied about. It's 1 second. In subsection 2 of section 13, the agency shall not issue an environmental permit unless the agency is satisfied that You see, that EIA is only one aspect of many aspects. That's why that A, the developer can comply with the terms and conditions of the environmental permit, not the laws. And B, the developer can pay compensation for any loss or damage which may arise from the project or breach of any of the terms or conditions of the environmental permit. So it's a necessary tool that Parliament saw fit to give or make at the disposal of the EP. And that is why joint and several obligation wouldn't do. You can't, on basic principle contract law, you cannot agree amongst or intercede with your friend that you joint and several liable. It doesn't matter for you and them. But the law, this EPA doesn't provide for that. The Petroleum Act, which is 1985, talks about that. But whilst we're in that tool, may I take this opportunity to immediately draw your attention? And this is a key to the how you approach then.
Sorry, before you, Mr. Satcham, before we go on there, just to stay for a moment with the section to which you referred us, section 13.2, yeah. So the agency shall not issue an environmental permit unless the agency is satisfied that the developer can comply with the terms and conditions
Yes.
of the environmental permit.
Yes.
Now, the terms and conditions that we're talking about relate to the operational aspects of the project, surely.
Yes.
Okay, so if let us say the other two parties, I don't mean to be disparaging or anything like that, but let's call them financiers for the moment.
Yes.
Okay.
That's all right.
Okay, good. So if they are financiers, how can they comply with conditions to do, for example, with the use of best technology? Would that not more naturally fall on the remit of the developer, the person who's in charge of the day-to-day operations
I
of
beg
the
to
project?
disagree, and I stand firmly.
Sure, yes.
If they are financiers, then they don't need a PPL. A PPL, as the name suggests, is a petroleum production license, and that is the development consent. I don't need it, but I have it. I want a license for a firearm, but you don't use it. What do you do with it?
Yeah, yes, sorry. There wasn't a separate PPL granted to these persons, was there?
No,
There's a single PPL granted to the consortium.
to the consortium.
Okay, so, I'm just anticipating what the other side may say. I mean, they may say, well, look, this consortium cannot go forward in executing the project unless it has certain partners. And one partner is a financial partner. This person provides the money, but they're not involved in any way in the operational aspects of the project. So that answers the question as to why a PPL is granted to the consortium. It's granted to the consortium because in order for the consortium to behave viably, it needs persons who are going to finance the operations of the project.
Your Honor, then they should have stopped with the petroleum agreement. And the two others don't go ahead with the PPL or with the permit, or to say that they have protection under the umbrella of the permit granted to SO. That is how we see it, with respect. Because when we look at section 10 at page 20 of the Act, developer means the applicant for environmental authorization for a project. And for a project is repeated in section 11. Project is defined there too, and you'll see the definition under section 10 is very, very wide. Project means the execution of construction works or other installations or scheme, any prescribed process or alteration thereof, any interference with the ecosystem, etc., or any project is listed in the fourth schedule and shall include public and private projects. So what we have a serious problem with is the minister granting them what we call respectfully development consent via the PPL. He was not entitled to do so because a prerequisite, as the minister himself in his affidavit, we have pointed out, admitted. I'm a letter from Mr. Edward Locke, senior counsel, has we have pointed out certain facts which are not in dispute. The minister is a public authority. You need environmental permit before you can get a PPL. They did not have a permit.
Mr. Jerem,
Yes, sir.
I'm looking at the relief
Yes.
that you have now particularized at the end of your submission.
Yes, Your Honor. Yes, Your Honor.
I know what your notice of appeal says. It's wide ranging,
Yes.
but in the best tradition of advocacy,
Yes.
you have narrowed down now before the court what it is you're asking for.
Your Honor.
And hold on.
Your Honor. Sorry.
Sorry. Oh, you want to preempt me? Preempt me.
No, I say there are only 3 reliefs I will carry you with. I had said I concede because I don't want it to be said I interrupted that Guyana's revenue. I said sever partial social right, quashing the PPL. It's so far as it joins the other 2 who don't have an environmental permit.
Right.
We want a declaration under the time limit for Judicial Decisions Act, and indeed, I think the Constitution says 147 of the Constitution, I believe, Your Honors.
Mr. Jairam, I want to commend you for just taking me away from the point which you admitted fleetingly, but which was really the main thrust of
Yes.
my inquiry of you.
Yes, well, I would be
Would
happy.
you permit me to stay there?
Yes,
Thanks, you're very gracious. Yeah, what you're asking for is an order that the PPL, that there be deleted the names of Hess and Sinok, and
yes,
to issue a corrected PPL in the sole name of Exxon. So that's what you are asking for. That is the effective,
Yes.
the practical relief that you're seeking.
yes, yes.
Okay.
I didn't want to ask the question because
So don't worry about quashing it. What we are focusing on is what is therefore effectively what it is you are doing, what it is, what will occur apart from, and I'm really very serious about this, apart from the change in a piece of paper as to who is the owner of the license. As my brother has indicated or inquired earlier, these other 2, they are not doing anything, so they claim. You do not accept that that is a fact, but they claim that they are not doing anything on the ground. They are having no connection whatsoever with what takes place in relation to the environment. Therefore, apart from therefore taking their names off this piece of paper, what else would you be achieving from us?
Counsel, if I may, you referred us to the definition of project in section 10. If we could go back there, because one of the things that notices that there's no reference to financial partners or anything like that in the definition of project. Do you,
there's nothing but financial partners.
yeah, do you care to expand on that, or? You
I'm sure my brother is asking that in the context of what I asked.
Yes.
So could you answer my question first and then just segue into his?
I say,
You do this, Mr. Jairam, I have to fight to get my question in your focus.
I hope it's not with me.
No, I did not think so.
I am much obliged.
Yes. Tell me, apart from a paper action,
Well, your Honor, don't pigeonhole me like that. Because not a paper alone, it has a practical, pragmatic.
tell me what it is.
It is, therefore, that insofar as Hess and Sinok are concerned, they cannot carry out any oil operations. And as it is, I don't know whether Guyana or the agency has the technology or the wherewithal or what have you to to investigate the ground, the actual site where petroleum is being extracted. It's not a mere paper. We could test with all cases. Paper, your birth certificate has an effect, marriage certificate has an effect, and so many things. Our universities and
But
qualifications.
you are inquiring into a question of fact. They say they are not doing anything. The minister obviously accepts that they are not doing anything.
Well, why must I accept the minister's word? It is not a
Because you are not the regulator.
and he's not the regulator either.
He is the enforcer of the law.
No,
All right.
no, with
Good.
respect.
Okay.
Your Honor. And so far as the EPA is concerned, the sole competent authority
All right.
is the Environmental Agency,
Okay.
Protection Agency. Please,
Whose ministry is that under?
I suppose Ministry of the Environment.
Okay.
He's Minister of Natural Resources.
Okay. There we go. All right.
I think the point is that if you remove these two entities, the scope of the works
Change.
will be the same. The anticipated works would be the same. The risks to the environment would be the same. The responsibility for the remediation of any harm would be the same. Is that correct?
I don't know if it will be the same. I say to you, in answer to that question, Mr. President, I say this apex court must uphold the law of the land. And there are too many uncertainties. What may take place on the ground, we don't know. And it is clear, you know, the minister was alive to it when he entered in the petroleum agreement, because he says that the contractor must, and all three are defined as contractor, must obtain a permit. And when the permit was applied for, only one, not the three of them. So it's self-contradictory. Remember the clause 1.18, Your Honors, I pointed out. The contractor shall, and there's a definition of contractor, means all three of them. So they are in breach of their own agreement with the minister. You can't, with greatest respect, Your Honors, you cannot sanction breach of the law like that. It is not fanciful on our part. It is not academic. It's a practical thing.
What's the practical aspect of it? Again?
You have to get,
You remove the name.
well, quash the entire thing and let the SO apply alone.
Your relief says take those two off.
Well,
Quash the entire thing is the fallback.
I was trying to be reasonable.
I see. Well, there you go. Stay reasonable.
And the PPL, which is at page 942, the minister calls them, you know, when we draft agreement or deeds and so on, hearing after court, without any evidence. Your Honors, bear in mind they did not produce evidence that they are co-venturers or partners or whatever. He said, herein after referred to as a joint venture licensees. Maybe the shorthand expression. And in the next page, page 943, at the full paragraph, I think that is called the addendum in deeds, conferring on the joint licenses, hereinafter referred as the licensee. So there one licensee, and then at H, and I have to point out, at page 944, at H, the minister hereby approves the operator, SO, short name, which operator may only be changed by the license to another party not comprising the licensee with the written consent of the minister. But the licensee at page 943 is all three. You
Yes,
see-
but sorry, you glided over the definition of the operator rather quickly there.
Sorry.
And I think with respect, that's important. I'm looking at the petroleum agreement between, as the President said, the government of Guyana and the three parties. And of course, that agreement is made pursuant to legislative authority, as you would agree. And the agreement provides in 2.2 as to who the operator is, who the person is, who is going to be conducting the day-to-day activities under the project, and it is clearly ESO. Now, I took some thought when I read this, because it does seem as if the operator can transfer its operational duties to somebody else within the consortium
With the consent of the minister.
without the consent of the minister.
I don't think so, Your Honor.
I think so. I think it can transfer without the consent of the minister. It simply has to notify the minister. If it is transferring its operational obligations to a party outside of the consortium, then it needs the consent of the minister. That's my reading of it. So, well, maybe you want to have a look.
Then if I
Article
was
2.2.
grateful, I'm
Yes.
grateful for that intervention and pointing out to me
Indeed.
respectfully.
Yes. But this is where, assuming,
ESO can transfer them willy-nilly overnight.
yes, it
And
did.
they're operating without a permit.
Absolutely. Well, I'm not sure I go that far, but I agree with you
That's a
firstly.
logical conclusion.
No, I agree with you firstly that from my reading of this, and I'll be interested to see what the other side says, ESO can transfer its operational responsibilities, if you will,
Yes.
under the tripartite agreement to any other of the other two parties without the consent of the minister, just notifying the minister.
Yes.
What I thought, though, is that if that were to happen, that would still not allow any of the other two to conduct those operational activities. Because if they were to try to do that, they would be doing something which is illegal under the laws of the Republic of Guyana, going back through to the Constitution, if you will. So that is what I wanted. I think I asked you before. If you were to agree with that, does that not give you the comfort that you are seeking? Because nobody else other than ESO can conduct operational activities in relation to this project without an environmental permit. I put it another way. The PPL granted by the minister cannot override the requirement for an environmental permit.
It cannot override, nor was it properly granted, because a precondition or prerequisite to the PPL is a permit from the environmental agency. From the agency.
Mr. Server, I understand you perfectly, and I understand that's one way of looking at it. Could I invite you there to consider that another way of looking at it is that the minister could say, look, I'm granting this PPL because this project, this contractor, they have collectively, if you will, an environmental permit. And the person with the environmental permit is the operator. Okay? So as far as my granting of this permit is concerned, it is perfectly lawful. If things change later on, and the operator transfers operational responsibilities to another of the tripartite arrangement, then that permit no longer validates the operation by one of the other three in relation to the operational aspects of the project. Am I in the same ballpark, basically?
Let me perhaps put it a different way.
Yes.
This petroleum agreement, except for background purposes, has no relevance to the case, because the honorable minister, as mighty as he or she may be, cannot override the functions, authority, and duties of the agency.
Makes my point.
So, what we are concerned with essentially, this is background because it doesn't appear in a vacuum or out in the blue sky. We are concerned with, one, the environmental permit and the PPL, because the PPL equals development consent. And without any prohibition or restriction in that, the honorable minister has granted them development consent. So they can proceed in any which way. And we are saying,
You would only have about 7 more minutes. Now, as I understand it, you're saying that a prerequisite for a PPL is a permit, that CNOOC and HES do not have a permit.
That's
And
right.
therefore, the grant of the PPL to them, or they being included in the grant to ESO of the PPL was unlawful. And you're
Unlawful.
asking that the PPL be amended to quash the grant to this and to CINO. That's the gist of your argument.
Yes. That's the gist.
Mr. Burgess, Justice Burgess, I think we didn't get a chance to have him answer your question, so maybe you could answer that
yes,
question.
yeah, sorry, Counsel. Yes. The question.
Section 10.
Yes, sorry, there are just two. There are
Yes.
just two questions which are they're interrelated. Which I want to raise. In light of the definition of project in section 10, would it be possible for HES and CNOC to apply for environmental prevention permit?
They can't, well, if they propose to carry out activities concerning the environment, they're required by law to get an
No,
environment.
no, given their role, their admitted role as financiers.
Well, I don't know if that is their role.
Assume it.
But
That's an assumption.
yeah, this is what we're told. This is what this is what ESOS tells us.
No, that's submissions, Your Honor. Submissions. There was no affidavit evidence before either of the
Yes.
court to
Yes.
say that there
But
was.
yes, assuming that these submissions have legs on which to stand, the question which I'm raising with you is whether HES or CNO could apply, given the definition of project, could they apply to the environment?
Well, if you're mayor, I would say provisionally, because I need to consider. Like I quickly in my head I narrated, I use it comparison as odious, but company and directors. Company has an obligation, my security for cost, for example, and one of the directors may be a backer
No,
of the company.
what is engaging my attention still is that when I look at that national project, and we have heard from the other side that permission is given in respect of the project. When I look at the definition of project, it doesn't seem to contemplate financial activities or anything.
I say now I understand you more fully. I was a bit precisely. The definition of project does not contemplate investors, if I may use that one expression, investor or investors. If they are contributing financially, they are an investor, in the position of an investor. And therefore, you don't need a PPL. You need some other arrangement, loan agreement, guarantee from SO and so on and so on, if SO wants you. Why you come and get, so, you know, it just raised alarm bells.
So the answer to my question is that HES and CNOC couldn't apply.
They're not entitled to.
Thank you.
Mr. Chairman, before you close, going back to what my brother, Mr. Justice Barrow asked.
Yes, believe me.
So you're seeking to sever the licensees then on PPL.
Yes.
So that CNOT and tests are removed. And the basis for that severance then, I take it, finds its way in your notice of appeal. So you say at 3D that you sought a declaration that the minister had acted in breach of section 14
Yes.
of the act. So you still wish us to make that, because there must be some basis
Yes.
on which a severance will take place.
But Your Honors, you see,
No, I just wanted to make sure
Yes.
that you're still
Yes.
seeking
I am
that
seeking-
declaration.
oh, that's crucial. And we also want a declaration with respect which we have sought through since the Court of Appeal. The courts in Guyana, despite the constitutional section Article 147 and the act which we have quoted, the time limit for judicial decision act. I know my learned friend, Mr. Datadine, says, well, you know, Ramon, Gaskin didn't suffer any prejudice. That's par for the court.
Mr. Jerem, on that issue of the declaration, do you know how many judges are constitutionally required, or the number of judges that should be deployed in Guyana?
Your Honor, let me answer it this way. A declaration will
No. I'm asking you a question. Do you know how
Fancy
many?
offhand.
Good. Do you know how many were in office at the time this case came before the Chief Justice? Do you know what are the constraints under which
I cannot.
he was operating at the time this case came before? You don't know those things.
But Your Honor,
So, just a minute. So, to ask this court to require the judiciary to produce outputs without any regard as to all of the materials and supports that are necessary to produce those outputs within the required time, how do we square that equation?
Your Honor, first of all, this is not personal against any judge.
No, it isn't.
It is a system. A declaration will serve a purpose and a significant purpose, reminding the executive that they pass legislation.
Yeah, but the
they haven't
declaration,
invoked
the
it.
declaration that you then need is a declaration to put in place all the materials and all the supports and all the assistance that are necessary
whatever
in order for
declaration-
judges to do
whatever
their work.
declaration-
But this declaration is aimed at impugning
Well,
the
you could
judicial
say-
functionaries.
You could say, Mr. Jairam, without attacking the integrity of the Honorable Judge, Chief Justice acting, and the Court of Appeal. This is to remind either they need to do something in Guyana, revoke the act, but you can't have it as a dead letter law. It's on the statute books, and it's consistent with section with Article 147, and she has taken a very long time. Now, Your Honors,
Nobody's ever raised the argument as to the
Constitutionality.
constitutionality of that particular piece of legislation.
Well-
But listen, you see that part of your case, we will take it on written submissions.
all right.
And Mr. Jairam, we will bear in mind that you did not join the Attorney General, yeah?
The Attorney General,
As a representative of the government of Guyana,
I think he tried to.
no, hold on, who have the obligation to staff the judiciary properly and who bear ultimate responsibility if a judgment is not produced in proper time, yeah?
Your Honor, he tried to join,
Uh-huh.
and I
And
objected.
I'm glad for your candor.
You know, there's one other point, Mr. Jairam, I'd like to engage you on before you,
Even though you're past your time.
even though you're past your time.
Yes, you are.
Yeah, I think we have been largely responsible for that. So that's
Can, Your Honor.
subject to the president's ruling. I think that's fine. What I wanted to ask you about is where you started.
Yes.
Because you started with the constitutional principles,
Yeah.
and you started with a reference to one of them, which spoke to the duty of citizens to take action basically
Yeah.
in the interests of the environment.
Yeah.
We don't know how this appeal will go,
No.
but if it were to go against you, and I'm not for a moment suggesting it will, but if it were to, how would that reference be relevant if and when we come to the issue of costs?
Well, first of all, if you rule against us in face of all the authorities and the provisions of the Act, when you look at Section 7,
Well, yes, as I try to say, we're not there at all. And let's try.
will have a chilling effect of public-spirited citizens wanting to bring challenge by administrative action people who are degrading the environment. So if you agree with me, we would want costs.
Yes.
But I would ask you, like the South African example, where public-spirited citizens bring and they lose, the court doesn't award any cost because it will have chilling effect of people, of public-spirited Guyanese trying to.
Mr. Jairam, you are a practitioner in the Eastern Caribbean courts.
A little bit.
I seem to recall.
Yeah, I appeared before you in those.
There we go. You are therefore familiar with the legislation in relation to costs or the rules in relation to costs in that jurisdiction.
Yes.
And there is a preservation for public-spirited persons to not have to pay costs.
Yes.
And then there's a little carve-out, isn't there? Tell us what it is.
I can't remember offhand.
Shall I help you?
Well, it's second your
Huh?
elucidation on,
No. It's just a little reminder.
yeah.
That, however, if you persist in litigation, which you really ought not to be persisting in, then that protection from costs does not continue to obtain. So if, for instance, now hypothetically, Mr. Jairam, yeah, because as my brother said, we do not know which way this case will turn out.
Yes.
But if it turns out that you lost in the High Court, you lost in the Court of Appeal, and you have come before us, and if, capital if, bold, if you lose here, then it may be that you really should have stopped at an earlier stage.
Well, Your Honor will be hard pressed to say this is a frivolous and vexatious action. I am sure of that. I stake my little reputation.
That was not the term used, frivolous and vexatious.
Well, I'm saying the law is not static.
Okay, there we go.
And I suppose the point you're making is that this is the first time this point has ever come before this court.
And we need some kind of pronouncement.
And I must say, I'm very much indebted to the submissions by parties on all sides. But I had to go and do some research outside even of those submissions, and I really haven't found anything that expresses a decisive view on the precise question that you have raised. So I assume you want to ground the current submission in that kind of environment, no pun intended, where we have not had the benefit of any jurisprudential pronouncements on this, and also ground it as well, as you said at the beginning, in the Constitution, which places a responsibility on citizens to take active steps to ensure protection of the environment.
Your Honor, I'm so grateful to you.
I may have the last word, Mr. Jairam. I think the other side will be hard pressed to mount a contrary argument after my brother's very open appeal
And
to
again,
public interest.
I'm indebted to you. There's one last thing, if I have time. Yes,
You don't, but you will take it.
regrettable. Is regrettable. This judgment was given since with the Court of Appeal. We have it in the in our submissions. Court will give judgment 21st of December 2022. Last night when I was working at 11, after 11, I received the Court of Appeal judgment. And I'm not so sure it is in accordance with this transcript that we have. And the transcript is at page 15 of 37. But there is something in there which the learned chancellor at paragraph 36, that's page 255 of 265, on behalf of the court says, because this is the only written judgment, this court finds favor with the submissions of Mr. Locke, senior counsel. Full stop. Section 14, that's section 14 of the, makes it undoubtedly clear that the process of issuing a license pursuant to the Petroleum Act is predicated on a license obtaining an environmental authorization permit. That is a concession by Mr. Loku. And Mr. Loku, in these submission before your honors, also accepted that. So, 36, Your Honor. 36, at page 2055.
I think you have teed him up very, very well. So no doubt he'll respond to that.
Well, I have to give credit to Mr. Loku in the space. And you will see, Your Honor, in our submissions, written submissions, we have said what facts, and there are 5 essential things, including the passage in Benyon, a plain and ordinary meaning. Your Honors, I don't wish to overstep the boundaries of the time unless I had much more to say, but I suppose you have read and you have asked me pertinent questions. Can I be of further assistance?
Yes, well, thank you very much. We have your submissions, and I think we understand the gist of your argument, which I tried to very briefly, very succinctly summarize. So thank you very much.
Yeah, I'm much obliged.
Mr. Laku?
Your Honors, it's nice to be back at headquarters.
Nice to have you back.
Your Honors, could I deal briefly with, because it did concern me when I read what the Court of Appeal said was my submission paragraph. I only got this at around midnight last night when I was trying to earn some quick sleep after long traveling. But nonetheless, I had a look at it and it did concern me. There's some words which should be after. It reads this way: the process of issuing a license pursuant to the Petroleum Exploration and Production Act is predicated on a licensee obtaining an environmental authorization permit. The words which are missing there, devil's printers, Your Honor, for a project. Never have I submitted before any court, either at first instance or in the Court of Appeal or in my submissions here, that every licensee has to have an environmental permit. That is contrary to the entire case and submissions put forward on my part. I just want to clarify that.
Yeah, this is you on that issue. For my own edification, is it possible for any entity other than the permit holder and the co-venturers to be granted a license in respect of the same project of which the permit holder has a permit? Do you understand?
Yeah, I do. I think I do, Your Honor, and correct me if I'm wrong. And I think if you look at the petroleum agreement, it provides for the minister to be able to grant a license to any person identified in the agreement or any company yet to be formed, which would seem to indicate that the Petroleum Act, which has statutory beginning, contemplates is carrying out a function of an operator who does not have an environmental permit. I think it may have been Justice Anderson. And that has concerned me at some time. My view on that is this: the correct to determine who ought to hold an environmental permit is the agency. And I would say that if someone is applying to carry out the functions of an operator, and that person does not have a permit, the agency is quite empowered and would quite be entitled to say to that person, I am not granting you the position of an operator unless you obtain an environmental permit. I'm not so sure whether that will entail having to carry out a new environmental impact assessment, because that's already been carried out. It may or may not. But that is a matter for the agency. And that is a matter particularly within the jurisdiction of the agency. But it is a very valid point, because if you're going to change an operator, I think the agency must be in a position to say to that operator, you must have an environmental permit. That doesn't arise in this case.
Could we stay with that point? Because I think it's really the critical point in these proceedings. First of all, it seems that Article 2.2 of the agreement, as I was saying earlier to Mr. Jaram, does allow for the transfer of operational responsibilities to another member of the consortium without the consent of the minister. I think it really requires notification to the minister. If it's being transferred, the operational aspects, to somebody outside of the consortium, then requires the minister's consent. But in either case, I would have thought that the new operator, if you will, must obtain the environmental permit of the agency. Or put another way,
You comply with the conditions of the environmental permit.
well, if not, you'll be breaching the laws of Guyana, which require that in order to conduct projects affecting have an environmental permit.
That is clear, Your Honor.
Exactly.
And therefore, it would be a matter for the environmental agency, who has the control and jurisdiction and authority over that sector, to say to you, I will approve you as an operator, but you must come and get your environmental permit. As I say, I'm not sure whether you'll need to carry out a new environmental impact assessment. That's another matter. It could be argued that once an environmental impact assessment is carried out in respect of a project, you don't need another environmental impact assessment, because you'll be assessing the same things.
Well, not necessarily. I mean, the point is that the impact assessment does relate to some extent to the particular operator who presents himself for the application for the permit.
Technology they're going to use.
Absolutely. As the president says, the technology that they're going to use, that is the person who must give the undertaking to use the best available technology and so on. So I could see very well that if the agency were to say, look, we don't need another environmental impact assessment, I could see Mr. Jaram saying, no, not so fast. You need an environmental impact assessment. So let us not speculate. But what we are seeing, I think, and I think you're great, and I think I saw it in your written submissions, that if somebody other than the authorized operator starts to operate a project, that person must obtain, in order to do so, an environmental permit from the agency.
That would seem very sound, Your
Honor. Wonderful.
Do you go further to suggest that if CNOC and even if CNOC and HES were to assume the role of operator, then they too, because no permit had been granted to them specifically, would be in breach of the law?
That is quite so, Your Honor. Not only would it be in breach of the law, but it would be in breach of the permit which has been issued to ESO. Because the permit issued to ESO only permitted ESO, who are the operator, to carry out those functions as operator. Now,
Yes, this is Mr. Jaram's response to that is that, well, that is only binding on ESO. So,
what is on the
binding on ESO. So, I think what he's searching for, and I was trying to see if I could have assisted him, is general law, which applies across the board, across contracts. And that general law is that you cannot conduct a project in Guyana affecting the environment without having first obtained an environmental permit.
as an operator, Your Honor?
As an operator, of course, yes.
Yes, Your Honor, that is so.
Yes. Okay.
That is correct.
And the other argument that I believe Mr. Jaram makes is then, well, why you grant these two entities licenses? Because they have no permit, they can't operate, they can't pursue the functions of an operator So why was it necessary at all for the minister to go out of his way to include them in the permit?
Your Honor, I will address you to some parts of Gardner on the practice in petroleum industries very briefly, which shows that there are two types of partnerships in petroleum industries. There's the operational aspect of petroleum industries and the non-operational partners in petroleum industries, who for very many reasons need a license. It is the license which is bankable, under which the financing comes from for the petroleum industries. So the license is one thing. But you see, Your Honor, when you go back to really the essential case, which I haven't heard Mr. Jairam on at all, is where in the Environmental Protection Act does it require every licensee to have been the holder of an environmental permit once the project has been approved? That is why, Your Honor, I would like to go back to what is the fundamental issue in this case. I have no problem with the constitutional provisions. Article 149 says what Mr. Jairam says it says, but it also says this, that the state shall take reasonable legislative measures to give the protection under Section 149. How does the state do that? By the legislation of the Environmental Protection Act. So you have to come back to that legislation and look at what that legislation says about who may be given development consent in the form of a petroleum production license. And that is the interpretation of Section 14.1. And Section 14.1 does not say what the appellants wish it to say. They change the wording. They talk quite rightly about you must construe legislation in their ordinary and grammatical sense. But then what do, Your Honor? They change the wording in Section 14.1 to say this, that a PPL, and the submissions of the appellant can be found at page 993 and 995, paragraphs 11 and 25. And if I may take Your Honors there. Development consent cannot be granted to any person who does not have an EP. What they're saying that those are the ordinary, those are the words used in Section 14. But Section 14 doesn't say that at all. For Section 14 to say that now, they will have to assume the function of Parliament. What Section 14 says, a public authority shall not give development consent in any matter where an environmental authorization is required, unless such authorization has been issued. Here it has been issued. The permit for the project, I agree, it's issued to a person. It has to be applied for by someone, and it has to be issued to someone. But what is it for? It is issued for the project. And I ask Your Honor to look at the narrow meaning of developer in Section 10.
Counsel, isn't to a person implied or to some individual implied? Isn't that implied in the section? It doesn't, I agree with you, it doesn't expressly say that, but can you give permission to a project? You can give permission for a project, but can you give permission or consent to a project?
No, but I think you can approve the project. But
But we're not talking
in
about
any
approval.
matter, I think the important words are in any matter, which I do not think can in any way be restricted to any person.
But before any matter comes consent in any matter. So consent presupposes. There's implied in the giving of consent. Isn't there implied that consent has to be given to some person, something?
That person is the applicant for the environmental permit. And that is why I ask Your Honor to look very carefully at the wording of Section 10 of the Environmental Protection Act. Section 10 has a very restricted meaning of developer. It it's under the heading Environmental Impact Assessments. For the purposes of this part, that is part 4, developer means the applicant for the environmental authorization for a project. Only for this part, developer has that restricted meaning, the applicant. Somebody, I agree with Your Honor, the project can't apply. Someone has to apply. And that person is called under that part the developer. But when you look now at what...
While you're on section 10, a question which I raised with counsel was, doesn't project narrow the kinds of persons who could apply as a developer? Doesn't the definition of project narrow it to the function which you identified as the persons who are doing the operational? You made reference to some text earlier.
Yes, which would seem to mean, Your Honor, that persons who are not involved in these kind of activities
Would not,
within the meaning of project would not be entitled at all to apply for an
Am I
environmental
right in
permit.
believing that?
Your Honor, as you're on that point, may I go briefly to those? Gordon, some excellent text on. It's all these texts are before Your Honor. I filed them. And I'm referring to, because this covers a lot of the areas which have come up before in the repertoire between Mr. Jairam and yourselves. I'm referring to offshore petroleum activities. No. Oh, yes. UK oil and gas, current practice and emerging trends. Volume 1, Resource Management and Regulatory Law, 3rd edition by Greg Gordon. And, Your Honor, if I may just briefly refer to some short passages. And all these authorities are before Your Honors. Oh, Your Honor, before I forget, my learned friend had said that there was no evidence of the activities carried on by S&C and OOC, and it was only in submissions. That is not so, Your Honor. I refer to the submissions at page 1032. Those are submissions of the respondent, which sets out precisely the affidavit, the references to the affidavit evidence which show that only SO as the operator and not any non-operator carries out such activities. Paragraph 58 of the affidavit of Henson at page 431, and the operator companies simply reimburse SO for the financial outlays and expenditure incurred on their behalf in SO's carrying out petroleum operations, paragraph 41, page 419, and HES are not and have never been operators and carry out no petroleum operations within the LISA 1 project. So it is unfair for my learned friend to come to this court and say that there is no such evidence and we're only relying on submissions. Your Honor, if I may refer to Gordon's text, it's and the first short passage, very short passages, I won't before Your Honor long on them. They're at 1179 attached to the submissions of the respondent. The two classes of co-venturer, the operator and the non-operator. There are two classes of member of the joint operating agreement. The operator who actually executes the collective will venture and is responsible for the day-to-day management of the joint venture operations. And the other members who are simply designated as non-operators. Then it goes on to talk about the operator, which is a point which has come up continuously this morning. The operator is responsible for the day-to-day exploration, development, and production activities in the venture, whilst the remaining interest holders are non-operating members who share in the cost and production, if any, of the joint venture activities. There is only ever a single operator, and the identity of the first operator in a given joint operation agreement will be specified in the agreement. The duties, broadly speaking, the operator, this is at page 1181, has the day-to-day responsibility for the conduct of the exploration. And another book, text by William Hughes, says this: the joint operation agreement typically grants to the operator the broadest measure of authority in regard to the project to oversee and supervise the work program, prepare and comply with budgets, report to non-operating participants and host country on project operations, assure compliance with all applicable laws, and maintain the license in effect by meeting all necessary conditions. Now, Your Honor.
Counsel, sorry.
Yes.
Sorry to interrupt.
No,
you
no,
again.
go right ahead.
Isn't this consistent with the definition in section 10? Isn't it consistent with only an operator can be a developer and therefore can apply for licenses?
Not at all, Your Honor.
Could you help me to see?
Well, yes, because to look at that, I would ask you to go back to section 14.1 of the EP Act.
That's right.
If I can take you back there.
Please do.
Because that, Your Honor, is what Your Honors will have to look at to determine essentially whether granted a license must have been granted a permit. And it is my respectful submission on that aspect that
How does section 14 help
Oh,
us to
because
answer that?
that is the section, Your Honor, which the appellants say the minister's been in breach of.
Yes, but how does it help us to answer that?
It tells us what the minister, in what circumstances the minister can give development consent. And it is common ground in this case, Your Honor, that development consent, the PPL constitutes the development consent. But Your Honor would notice section 2, which was cited by my learned friend. Developer has a much broader meaning in section 2. Development consent in section 2 means the decision of the public authority to proceed with the project. So you may have a developer in more than one stage. Under section 10, you have a developer which is restricted for that part only to the applicant for the permit.
Does it say for that part, for the purposes of purposes of this part?
Of a project. Your Honor, it's at page 20 of the Act, section 10. Developer means the applicant for environmental authorization for a project of, or the state initiating a project.
Yeah,
For the
for project.
purposes of this part.
Yes, yes. Means applicant.
Yes. In other acts, in other legislation which I've put before Your Honors,
For
that
a
person
project,
is put
sorry,
the operator,
sorry.
called the operator, you know, it's the operator in other jurisdictions who apply.
Yes, okay. I'm trying to understand. The developer applies, is the person who's applying for a project.
That's
So we
right.
look to see what a project means. And a project is limited to what the book that you just read refers to as an operator, doesn't it? And the non-operated person who is given management and financial advice and so on, that person is not an operator. It's by definition, the person is a non-operator.
That is quite so.
So when we look at project, the definition, when certainly I look at it, the definition of project seems to contemplate only the operator. It doesn't seem to include the non-operator.
as the applicant for the permit.
That's quite correct.
But that does not necessarily mean that only the applicant for permit can be given a license.
I concede that.
That is my point, Your Honor.
Yes, but section 14 makes it impossible to give the PPL without being issued first with an environmental permit. Am I right in
Yes,
saying
Your
that?
Honor. And then Your Honor has to look at what was the environmental permit issued for. I agree
But
with Your Honor.
But it couldn't be on your analysis. It couldn't be given to Hess and Sino because they were non-operators.
That is so, Your Honor, but that does not prohibit them from getting a license. Nowhere in the Act. I agree with Your Honor that this
Would it make it easier to say that it will prohibit them from getting an individual license, but not as members of a
Joint consortium.
single joint consortium? That consortium who has, of course, a permit holder in the form of the operator, from getting a license.
Yes, Your Honor, and particularly when you look at Section 9.3 of the Petroleum Production Act, which says this. A license may be granted to two or more persons associated together in any form of joint arrangement.
Where is that?
Section 9.3 of the Petroleum Exploration and Production Act, Chapter 6504. Sorry, not 9.3, I'm very sorry, 9.2. A license may be granted to two or more persons associated together in any form of joint arrangement if each one of them is qualified to hold the license under subsection 1. And nowhere in subsection 1 is there any requirement of an environmental permit. Now, Your Honor, my learned friend raises this argument. He says, well, look, the EPA Act came after this act. But then when the legislation passed the EPA Act, the legislation must be taken to have been aware of the existing state of the legislation which would affect the matters with which the Environmental Protection Act dealt with. And if the environmental, I know they argued all kinds of things in the courts below, you know. They argued that the Environmental Protection Act repealed the petroleum, they seem to have abandoned that now, repealed the Petroleum Act. It couldn't do so. You know. It is not inconsistent with it. It can sit together. And the authorities seem to say, and I've cited those authorities, I wouldn't repeat them, they're well known to the court, that when new legislation is passed, the legislature is taken to have been cognizant of the existing state of the legislature and would have taken into consideration that the two acts should coexist in harmony. So if it was that the Environmental Protection Act had wished to impose the prohibition that only the holder of an environmental permit could eventually be granted development consent in the form of a petroleum production license, would not one have expected that that would be specifically enacted and not left to inference in the EP Act itself? Because the EP Act, when it was passed, they would have been aware of the existence of Section 9.2 of the Petroleum Production Act, which permitted the grant of a license to two or more persons acting in a joint venture consortium, which is what happens here. Which means that the legislation, when taken as a whole, clearly contemplates that has to be approved. It is approved when the permit is issued. I agree with Your Honor. It's issued to a person, but it's issued for a project. Once that permit is issued, the public authority, who is the minister in this case, can give development consent in any matter with regard to the project. So consent being given to a person other than the holder of an environmental permit. And having regard to the totality of the legislation in place then, and having regard to the fact that the legislation must have been aware of Section 9.2 of the Petroleum Act. If the...
Let me see if I capture
Yes, please.
your submission. You said that a person who is not a developer or operator cannot apply for a permit. If you're not a developer, if you're not
No,
engaged.
I didn't quite say that. I said the person who applies is called a developer under section.
Person who applies is called a developer. Okay, so person must be the one who is going to be doing the operational aspects.
Because he's looking at a project.
Right. But it doesn't follow that if you are not a permit holder, that you can't apply for or hold a license. You may obtain that license if you are a co-venturer with a permit holder and if you are not yourself engaged in the operational or the developmental aspects of the project. Would that be correct?
That would seem to be consistent with our legislative provisions as well as the international understanding of petroleum operations.
Let me just clarify that, Mr. Latour. If you are a non-operator, you cannot apply for an environmental permit. I wanted to get, can you?
Well, I would put it a little bit differently. If you are a non-operator, who becomes an operator? Because remember that operators can change under the petroleum agreement. So if you're, well, maybe I should answer your honest question first. If you're a non-operator, you wouldn't be carrying out a project. Therefore, you really would not be entitled to an environmental permit. You wouldn't need one.
You won't apply and you can't apply, is that right? You won't be given one.
You ought not to be given one.
Thank you. I didn't.
And that's the case of Sinok and Hess. They do not propose to engage themselves in operational aspects. So they were not involved in the application for the permit.
And contrary to what my learned friend is saying, there's evidence of that which has not been contradicted. That is the state of the evidence before this court. They have never carried out petroleum operations and will not carry out petroleum operations. And Your Honors, go further. The day they do try to do that without an environmental permit, they are subject not
Which
only
is Justice Anderson's point.
not only to criminal sanctions, but then that would create a breach of the SO permit, which under Section 13(1)(b) of the Environmental Protection Act, the agency would be entitled to cancel or suspend that permit. Because if someone else other than SO is carrying out those operations, that will be a breach of SO's permit. Now, Your Honor, what happens if they cancel and suspend that permit? Under Section 14(2) of the Environmental Protection Act, the license becomes canceled and suspended. So not only are they criminal sanctions, they risk the sanctions if by carrying out operations which they ought not to be carrying out and breaching SO's permit, they risk the cancellation of that permit, which would automatically under 14(2) lead to the suspension and cancellation of the petroleum production license.
Mr. Latour, I follow you on the question that I have for you, because this is important for the people of Guyana and the environment of Guyana. Who is the watchdog agency to ensure that these things are carried out in accordance with the law and with the various documents that we have?
There are two watchdogs. From the perspective of the environment, the watchdog is the agency. That is why I said earlier that the agency at any time can say to anybody, I am not allowing you to carry out these petroleum operations without a permit. They are the watchdogs.
Yeah, Mr. Latour, let me say therefore that your little side joke caused me a lot of trouble, because you said they ought not to. And it occurred to me, therefore, that I don't know, I'm not saying that they ought to, but it may be that you are trying to say to us that all is not well.
Not at all, Your
I
Honor.
wanted to
Oh, no.
get that straight.
Apart from
Your
it,
little joke didn't make,
as a matter
hold
of
on,
fact,
hold on.
yeah.
Your little joke didn't make me feel that they ought not to, but who knows? But I'm glad that you're able now to clarify it.
Your Honor, I often make jokes out of place. Yeah.
That's all right. It was helpful to me.
But Your Honor, I was coming to another point.
The second watchdog.
Point, yeah.
Yes.
The one watchdog in relation to the environmental matters is the agency. The other watchdog in relation to compliance with the licensing requirements is the minister. That's the other watchdog.
Could I suggest there's a third? There's a third watchdog, and that's the public.
Well,
And that's the public through the section in the Constitution to which Mr. Jaram referred earlier.
I never disputed that.
No, I'm just trying to supplement.
A watchdog. I think they're a caretaker.
Wonderful. I'm happy to accept that. Thank you.
Yes. And Your Honor, it's interesting to note that under section 20 Roman 1 of the license, my memory is not always very good these days, so let's make sure I'm correct. Yes. The license, and this is a very important section in the license. The licensee, which comprises all three, shall abide by the Environmental Protection Act 1996, regulations made thereunder, and the terms and conditions of the environmental permit issued by the Environmental Protection Agency, dated so and so. In other words, this license also tracks to its compliance. The compliance by all three licensees with the Environmental Protection License. And Your Honor, licenses, Your Honor, are not only contractual, they're also regulatory in nature. And I did have a reference to that. If you want to bear with me. The same text I had cited, Gordon, says this about the nature of licenses. Very interesting. It's in the submissions at page 1176, which I have filed with the court. A casual examination of UK oil and gas license might lead one to the conclusion that the license is simply a commercial contract. The license opening oration statement is made between of the one part and the other part. Referring to another text, Your Honor, the author says this: Daintiff and Hill are therefore fully justified in describing the license as contractual in form. However, the same authors are also surely to correct, are also surely correct to recognize that the license also fulfills another function. A close examination of the license makes it clear that it is as much a regulatory instrument as a document recording the terms of a commercial deal. Much of the license is given over to imposing a set of controls and obligations upon the licensee, the breach and non-observance of which may, amongst other lesser sanctions, result in the license being revoked. So it is quite permissible for the license as a regulatory instrument to incorporate adherence to some other instrument, in this case, the environmental permit, as a condition of the license. And Your Honor had mentioned...
Mr. Lacour, want to take a short break at this point, for 10 minutes, and then we'll come back. We'll have until about 12:35 when we come back, and then we'll take a lunch break. Then we hear from the added respondents about 1:30, and then the appellant's reply would be about 2:45. So let's just take a 10
You're
minute
gonna
break.
have how much time when we come back?
When we come back, you'll have up until 1:35. Sorry, 12:35.
All right, I so being honest.
You will not need it, Mr. Luku. I have every
No,
confidence.
no, you are. I've heard you. I've heard you already when we from this part of the bar table carry on too much.
All right.
Yes, Mr. Lockwood.
Yes, thank you very much, Your Honor. And just three short areas I wish to deal with. I may not take up the rest of the entire period. I see a smile from one part of the bench. Your Honor, one of the submissions of the appellant is in contending that SO and no one else can be granted in the circumstances of this case, a PPL, is that the appellant contends that an EP cannot be transferred from one permit holder to another, and the EP is therefore personal to the permit holder. And he says the Act does not, or the regulations do not permit an EP to be transferred. That is inaccurate, Your Honor. That submission is contained in the reply of the appellant, paragraph 9, 1790, at page 1791 of the record. Ninthly, the EP Act does not provide for permits to be transferred from one permit holder to another. Permits are personal to the permit holder. And it goes on to say something else which is not correct. The permit itself at condition 1.18 expressly prohibits SO from transferring the permit. That is also inaccurate. Your Honor, a permit under the Act and the regulations is assignable and transferable, and I refer to the Environmental Protection Act, section 33(2)(b).
Shall we repeat?
33,
2B.
2B.
Okay.
A person who makes a statement commits an offense for the purpose of obtaining the grant or transfer of an environmental permit. Now, how can you create an offense for transfer of an environmental permit if it's not transferable? 36(1)(c), Your Honor, the agency is required to keep a register containing particulars of each cancellation, revocation, variation, or transfer of an environmental permit. How can you keep a register of transfers if it's not permissible? And the environmental protection authorizations in 3 places clearly contemplate and authorize the transfer and assignments of environmental permits. First of all, Your Honor, at Regulation 9.2, where there's any change in the particulars furnished in the application or after the grant of an environmental authorization, the change has to be notified in writing immediately to the agency by the applicant, or as the case may be, by the developer or holder of such authorization, which clearly contemplates that a permit may be held by someone other than the original permit holder. And most important, Your Honor, if I may refer to Regulations 21, Roman 1, sorry, not Roman 1, 21.1, and which says this: no environmental authorization is assignable or transferable to any person without the prior consent of the agency having been obtained. Of course, it doesn't say it's not transferable, but the consent of the agency has to be obtained. And they will have to fulfill the same kind of requirements as to their ability, financial ability, technical ability, and so on, as the original applicant would have had to be provided on the 13.2 of the EP Act. And then, Your Honor, at paragraph 2, the agency may, on application of a holder of an environmental authorization, transfer his environmental authorization to another person. I don't know what could be clearer than that.
Sorry, which one is this?
21.2. The agency, on the application of the holder of an environmental authorization, may transfer his environmental authorization to another person. And under 21.4, it sets out what is to be contained in the application for transfer. I won't read them through. And under 21.9, even before the transfer is finalized and approved, it says this: where the proposed transferee occupies the facility before a final determination of the application is made by the agency, the conditions and restrictions of the permit shall be binding on the proposed transferee and shall be observed by him, notwithstanding that he is not yet the holder of an environmental authorization or that the environmental authorization may have expired. So, Your Honor, to submit that it is linked forever to the original permit holder and can never be assigned and transferred, as submitted by the appellant, is not correct. And then the appellant also refers to condition 1.18 of the PPL. Just guide Your Honors to that.
What page is it?
Yeah, I'm trying to locate it, please, Your Honor. Yes, at page 82, which provides this. They're saying, no, I'm very sorry, Your Honor. I'm very sorry. The environmental permit. Yeah. Yes.
What page?
At page 82. They're saying this clause of the environmental permit prohibits transfer and assignment of the permit. It doesn't, Your Honor. It says this: do not assign or transfer the environmental permit to any person without prior consent of the agency. Of course, the agency is entitled to consent. They're overseeing the whole environmental operations. But this is not a prohibition that you can never transfer or never assign. I just want to clear that submission up before briefly moving on to two other short aspects which I wish to deal with. Your Honor, it is submitted over and over by the applicant.
So, would you agree that any such transfer is subject to review, judicial review?
Is subject to, I'm sorry, Your Honor?
Judicial review, sorry.
The transfer?
Yes, if the agency agrees to permit the transfer of the environmental permit, I'm just asking if that decision of the agency
That
could
is
be
not-
subject to judicial review.
That is not an easy question to answer because generally speaking, where regulatory bodies conferred with powers to do certain things, the courts tend to defer to the decisions of the agency, bar three circumstances: if it is unlawful, if it is, what are the other two?
Irrational, maybe?
Irrational, and there's a third. I know there are three.
Procedurally improper.
Procedurally improper. Thank you very much, Your Honor.
But the answer is yes.
Yeah,
It-
yeah,
it
the
is
answer is
subject to, yeah, okay.
So generally speaking, you will defer, save in those three sets. of
Indeed,
circumstances.
yes, got you.
Your Honor, continuously the appellants have been submitting that the respondents' submissions on joint and several are a red herring and are irrelevant. Your Honor, the question of joint and several, it's still part of the grounds of appeal that the court misdirected themselves on the applications of principles of joint and several. But let us look at the history as to how the issue of joint and several arose. This was raised in the first place in the FDA by Mr. Gaskin. And if I advert, Your Honors, to paragraphs 28 to 32 of the FDA at pages 49 and 50, the argument of Mr. Gaskin was this: the effect of several obligations is that each of Hess, Esso, Nexon has a separate obligation to comply with petroleum production license and the petroleum agreement, including the obligations to comply with the Environmental Protection Act and obtain an environmental authorization. Then it goes on, paragraph 31, that I don't want to read the whole of it, but essentially paraphrased, that it is that these joint and several obligations should be applied distributively. In other words, the effect of a joint and several obligation is not that, which is the correct law as I understand it, that if one of the obligors performs the joint and several obligation, it is considered performed by all. They're saying no, it means it's distributively, which is a wrong interpretation of the law. And joint and several means each one has to separately comply with the joint and several obligations. And, Your Honor, it is as a result of that, there were long arguments at the Court of First Instance and in the Court of Appeal as to what was the meaning of joint and several. I haven't seen that they seem to be, and justly so, I think, they seem to have been abandoned in these submissions now, realizing the error of their ways in founding their FDA on this misconceived notion that joint and several means that each one separately has to comply. But nonetheless, it was not a red herring, and it is not an attempt to circumvent the EPA Act. It was merely a response to one of the main grounds which had been raised by the applicants as they then were in the FDA. And, Your Honor, I want to read on the question of joint and several because it deals with some issues which have arisen today, which deals with the clause in the license which incorporates the joint and several obligations of the licensee to comply with the environmental permit. And this part of Gordon's text, Your Honor, unfortunately is not with Your Honors in my bundle because I came across it afterwards. But it's a very interesting part, and I will make it available if the court so wishes. Perhaps it's at page 351 of Gordon's text, which I have adverted to before. Perhaps the first noteworthy model clause of Schedule 1 is Model Clause 1.2, which provides that wherever the licensee is more than one person, all obligations are joint and several. Thus, although it is not an expressly environmental clause, joint and several liability is a positive enforcement mechanism, as it ensures that should persons renege on their license, including any environmental obligations, others who are party thereto can be held accountable. Additionally, obligations may be enforced against whoever is the most suitable of the persons constituting the licensee. Your Honor, before I close and subject to what Your Honors may wish to ask me, there was one other issue, and I don't know if it's still being strenuously raised now. I didn't hear any submissions on it, but my learned friend has a right of reply. That the PPL was not validly granted to HES and CNOOC, which, Your Honor, is a surprising submission having regard sorry. The affidavit of defense of the added respondent, paragraph 34 at page 416, where the applicant, as he then was before he became appellant, after several sets of proceedings, and Your Honor will determine that in the question of cost later on, I suppose, if necessary. Raymond Gaskin, paragraph 54-57 states, PPL is granted to SO, HES, and Nexon, and CNOOC. And further, the affidavit of due execution of Henson describes him as a representative of SO, HES, and CNOOC. Those were the submissions, that was the affidavit in support of the original FDA, where they were saying that all three had been properly granted the licenses as far as form and procedure is concerned. Now they take a different position. And, Your Honor, I will refer you briefly, without going through it, to I know it's Exhibit HRH5 today. Under Section 14(1) of the Petroleum Production Act, before a license is granted, the minister sends to the potential licensees the conditions of the license. And those have to be accepted before the license is granted. And Exhibit RH5 and RH6, I can't right away put my hand on the exact references to them of the affidavit of Henson, which is the affidavit of defense of one, the added respondents. I won't deal with this much. I leave it to those representing the added respondent. Shows that both the minister had requested acceptance and that the licensees had responded by accepting the licenses in accordance with Section 14 of the Petroleum Production and Exploration Act. Your Honor, I hope within my time frame, completed the submissions, and subject to Your Honor's questions or any further questions Your Honors may wish to ask, those would be the extent of my submissions. I rely on the submissions which were filed before this court.
Just one or two very small things. I make the observation that in the petroleum agreement, there seems not to be any reference to the environment or environmental preservation or protection. I assume your response is that that concern is sufficiently dealt with the environmental permit.
Not only the environment permit, it's
yes.
also dealt with in the petroleum production license,
In
which
the
is
license.
issued pursuant to the petroleum agreement.
Indeed. Okay. I wanted to ask two other things very briefly. In response to Justice Barrow's interaction with your friend, I think at least in one of those interactions, your friend suggested that they would be content with the striking out from the PPL of the two members of the consortium other than ESSO, to whom the permit was granted, so that they'll be fine if Hess and CNOC were struck out from the PPL. I think I know the answer, but from your point of view, why would you not, I assume, why would you not agree to that action?
For two reasons, Your Honor. We submitted the license was properly granted to them, lawfully granted to them, and the minister did not act wrongfully in granting the license to them. And secondly, one has to understand that in petroleum operations, these are not cheap operations to undertake. They depend on large-scale loans from financial institutions. They depend on bankable documents to be able to acquire those loans. One of those main bankable documents are the licenses, which the financial institutions would require to see before I lend you X million or $1 billion to conduct these operations, and conduct them in a proper manner, or allow them to, or be part of a financing. Let me be careful now. Be part of a financing in the conducting of petroleum operations. I want to see your license. If to remove that license would create total chaos and confusion within the financial strata of the licensees. Now, you look at this situation, these operations have been going on since 2017. It's now 2024. As a matter of fact, petroleum exploration in the Liza 1 project has almost come to an end. Exploration. And that is the most environmentally concerning part of petroleum operations. I think there's very little left to explore. They know what's there. It's just a question of production. And so, Your Honor, for those two reasons, I would submit that I mean, it's up to the court in the end, but from our perspective, that is totally unacceptable.
Yeah. Okay. You actually have perhaps answered my last question, which in a sense, I think I might be challenging my brother Justice Witt, because he would, I'm sure, want to ask what is the state of the project right now that we are talking about?
Your Honor, perhaps my learned friend, Mr. Pollard, who represents SNCNOC, may be more fair with that. All I can say from my own knowledge is that as far as the LISA 1 project is concerned, we've been carrying out, SO's been carrying out operations since 2017 when the license was granted. And I know from my personal knowledge that the expiration phase is almost at the stage of completion.
So there was no stay granted pending the resolution of this issue?
Not at all, Your Honor.
Okay.
No, not at all. And I don't think there would have been any justification for stay, because what we would have argued there's no prospect of success, which is the main.
No, I'm not commenting one way or the other. I'm just curious about what the position is.
From my perspective.
Yes. Yeah. Okay.
And so to your knowledge, production has not yet begun.
Oh yes, production. Yeah, production and expiration take place simultaneously.
I
Your
see.
Honor. Production has commenced, I think, since 2020.
Oh, I see.
And so-
Okay.
One last question, Mr. Lecoux. I looked at Section 5 of the Act, which deals with deference to the environmental agency. Read that section as requiring the minister to refer the matter of granting of the license to Hess and GNOC before actually granting it?
What that requires, Your Honor, Section 5 uses the same wording, very similar wording to Section 14.1, and it comes back to the use of the word matter. Let me just find Section 5. No. The minister is a person or authority under a written law, which is the Petroleum Act, with the power in relation to the environment. I suppose it can be argued that the Petroleum Act does cover environmental matters, shall defer to the authority of the agency and shall request an environmental authorization from the agency before determining any matter. Here again, Your Honor, the same kind of wording than the use of the word any matter, which was used in Section 14, is used here again. And what is it that the authority has to require? The environmental authorization. And here, Your Honor, the minister would have said, I'm going to issue a petroleum production license. Therefore, what do I have to do to comply with Sections 5 and 14? The matter I am issuing the petroleum production license for is the LISA 1 project. What do I have to do to comply?
But
according to Section 5,
Counsel, sorry, my question is a very limited one, is whether that section contemplates or requires the minister before taking the decision to issue the PPL to the two, Hess and GNOC.
it requires the minister to ensure that an environmental authorization has been issued for the LISA 1 project.
So was it?
And he did so. An environmental authorization was so issued for the LISA 1.
By the environmental agency?
That is so, Your Honor.
Okay,
that,
thank
that
you.
is the, that has been tendered as the exhibit to Ramon
Okay,
Gaskin.
thank you.
R5.
Okay, we take the adjournment at this point, the luncheon adjournment, and we'll come back in an hour.
Thank you, Your Honor, very much for.
All right.
Yes, Mr. Pollard.
May it please your honors, as before I appear for the added respondents, your honors, I propose, although I do not propose to belabor some of the areas which have been traversed earlier, I believe there is one area that I need to contribute some further detail to, and that was the submission of my learned colleague for the appellant, that there is no evidence on the record that ESSO is the sole operator. Your honors, I would ask you, contrary to that, I would ask you to advert to the affidavit of the added respondents in the proceedings before the Honorable Chief Justice, and specifically to paragraph 58 of that affidavit, which is found at page 431 of the record.
431, Mr.
431.
Pollard, thank you.
Your honors, that paragraph sets out in considerable detail what functions ESSO performs as operator. And if I, with your leave, if I could read from it briefly. Among the duties undertaken by ESSO in its capacity as operator, and as part of its operations to enable petroleum production to commence from the Liza production area, are 1, designing all offshore production facilities and their supporting infrastructure; 2, engaging, directing, and paying all subcontractors; purchasing or leasing all materials and equipment; and chartering all vessels, in each case as may be needed to engineer, fabricate, construct, install, and operate the facilities that comprise the Liza 1 project; and 3, providing personnel that may directly carry out offshore or other field activity in support of the Liza 1 project execution. All of each activities and any other project activities of potential environmental significance are authorized by the permit. Notably, only ESSO as the operator and not any non-operator carries out such activities. Your honors, this I believe, and your honors, I would also briefly advert to the petroleum agreement and the petroleum production license. Under Article 2.2 of the petroleum agreement, that provides that ESSO shall be the operator charged with conducting the day-to-day activities of the contractor under this agreement. No transfer of operatorship to another party not comprising the contractor shall take effect unless it has been approved by the minister. And at Article B, the contractor shall provide the minister with a memorandum summarizing the operating agreements between the operator and the contractor, including any party comprising the contractor, for the conduct of petroleum operations, which will include, inter alia, a provision whereby the operator agrees to conduct the petroleum operations in accordance with this agreement, the licenses, and any applicable laws of Guyana. And petroleum operations, your honors, are defined in Article 1 of the Petroleum Agreement. as meaning prospecting operations and or production operations as defined in the PEPA, the Petroleum Exploration and Production Act. Section 2 of that act defines prospecting operations as operations carried out for or in connection with exploration for petroleum, and more importantly for our purposes, petroleum operations are defined as operations carried out for or in connection with the production of petroleum. ESSO is and has always been the sole operator and the only party that carries out prospecting or production operations. I therefore believe, Your Honors, that that is a rebuttal of the appellant's contention that there is no evidence on the record that ESSO has been the operator from the inception and is the only party which carries out, because all of these activities that I've just described and Mr. Henson has described in his affidavit are carried out by operators. Non-operators do not carry them out. I would therefore respectfully submit, Your Honors, that ESSO, that there is ample evidence that ESSO is, was, and has always been at all material times the sole operator of the project.
Mr. Pollack, could you remind me, does the Chief Justice in her judgment make reference to any of these points you've just made as to what evidence she may or may not have accepted?
No, Your Honors, I do not recall that. But if Your Honor would allow me to check the record of her decision, the decision is. I'm trying to locate, if Your Honors would bear with me, I'm trying to locate her decision. Ah, here it is.
Counsel, perhaps you can task your junior with finding it while you carry on,
Yes. Very well.
since you don't know offhand.
I don't, Your Honor, but it would appear that the Honorable Chief Justice was more focused on the permit being issued for the project.
Yeah.
There is reference to it in Article 38 of her judgment at page 538 of the record. In which she refers to Article 2 of the Petroleum Agreement, provides that it is made pursuant to Section 10 of the Petroleum Act. And paragraph 2.2 that I just adverted to in my reading, under the heading the operator, the quotation, ESSO shall be the operator, charged with conducting the day-to-day activities of the contractor under this agreement. Your Honor, the other aspect, there's another aspect that I would wish to deal with, which is the appellant alleges that the conditions of the no. Sorry, I turned the wrong page. The appellant submits at paragraph 65, Roman 3 of his written submissions that Hess and CNOC have not signed the PPL and SO has not signed it as their representative. And so it has not been validly issued to them. I suppose the implication there is that it is invalid for that reason. Under the terms of the joint operating agreement between the parties, SO as the operator is responsible for negotiating and concluding all arrangements with government. It acts as a representative of all three co-venturers. And evidence of that is found in the record. There was not an overt reference, or there was not a direct statement on this, because in the FDA, the affidavit in support of it, this was not a contention that was raised. And so the affidavit in defense, which traversed that, there was no need. It would have been prolix and unnecessary to put positive statements about that on it. But there is nevertheless evidence that shows SO's representation of the other co-venturers in its dealings with the government of Guyana. And I would ask your honors to take a look first at the affidavit of due execution of the petroleum license, which is found at page 130 of the record. Financial resources. It seems that there is a misprint here. But in any event, Your Honors, I would also advert to two further exhibits which are on the record at pages 447 and page 449 of the record.
You're not taking us to the affidavits of due execution again?
I did. I have to locate it because my notation here, page 130. Yes.
Because we have them at 958 and 959, Mr. Pollard.
You have the affidavit of due execution.
And we have two, one by Joanna Simmons Homer and one by James Douglas McGee.
Yes. Well, it is the affidavit of James Douglas McGee, Your Honors. If you look at that affidavit, it states that he saw the he saw the minister responsible for petroleum and Rodney Henson, the representative of ESSO Exploration and Production, Hess Exploration Guyana Limited, and CNOOC Nixon Petroleum Guyana Limited execute the petroleum production license. so that it is obvious that ESO executed the license both in its own capacity on its own behalf and on behalf of the other co-venturers. Your Honors, I would ask you to also advert to the Section 14.1 and Section 14.2 notices which are issued under the Petroleum or the then Petroleum Act. Those are statutory notices. Section 14.1 is a notice whereby if the minister proposes to grant a license, he is required to issue the licensee or licensees, the prospective licensees, with a notice setting out the conditions which are to be contained in that license.
Where will we find that, Mr. Pollard?
Page 447 of the record, Your Honor, and page 449 of the record would be the second one. There is a Section 14.2 notice, which is also issuable under the Act. And that requires the licensees to indicate within 60 days that they accept and agree to be bound by those conditions. And if Your Honor looks at the notice, it is the first notice, the minister's notice, at page 447. It is issued by the government of the Cooperative Republic of Guyana, represented herein by the minister responsible for petroleum, the minister. And it is issued to ESO Exploration and Production Guyana Limited on its own behalf and also on behalf of Hess Guyana Exploration Limited and CNOC Nexen Petroleum Guyana Limited, together, open parentheses, together the licensees, close parentheses. And if we turn to page 449, section 2 notice, that is issued by ESO Exploration and Production Guyana Limited on its own behalf and on behalf of Hess Guyana Exploration Limited and CNOC Nexen Petroleum Guyana Limited, together the licensees. And it is addressed to the minister, and it informs him that they accept and agree to be bound by the conditions contained in the notice. Your Honors, I would respectfully submit that these documents entered into between the three co-venturers and the minister clearly show that there is a course of dealing between the Guyana government and the licensees in which ESO was the operator and has functioned as a representative of the co-venturers for the purpose of entering into documentation and commitments with the government of Guyana. So that
Just one question, perhaps you already covered it and I did not hear. But Mr. Pollard, these are what I would consider private notices to sent from the minister to ESO. These are not published.
they are, Your Honor. There are deeds and they are filed as records in the deeds registry.
The notice
The
I'm
notices
talking
and the
about.
licenses and all of the supporting documents, they are filed in the deeds registry.
Thank you.
And I assume that you'd associate with Mr. Lecour in saying that this way of proceeding is consistent with industry practice across the oil and gas industry in various jurisdictions. Will you?
Yes, Your Honor. I have no difficulty with the submissions that Mr. Laku has made. They are reflected. You see, Your Honors, this project was conceptualized by ESO from since 1999. That was the year they first obtained a license in Guyana. ESSO has driven petroleum exploration in Guyana, and even in the questionable days with the border, Your Honors would know of the border controversy with Suriname, the maritime border, and there was a high state of tensions at that time. ESSO was actually required to suspend operations. And ESSO came to Guyana. ESSO carried out, obtained prospecting permits. ESSO has always believed in and pushed the development of hydrocarbons and the hydrocarbon industry in Guyana. It therefore conceptualized the project and applied for a permit. It is the developer of the project. It applied for the permit, and then having obtained the permit, because there's nothing in the Act, the same section 14 that we had spent some time on this morning, there is nothing in the Act that says that a developer, once they've obtained development consent, must proceed with the project alone. Once ESSO had obtained the permit, it was then free to proceed to the next stage of the project, which was a license. And it then extended the opportunity to HES and to CNOC to join it only as financial partners. Investors, I believe, was the term one of your honors had attached. And that has been the form that the project has taken up to the present time. And that is why I wished to apprise your honors of the details that go on with an operatorship, an ESSO, that ESSO is the only company that carries out those activities that I have just detailed. They are the only one who ever has, up to the present time.
And do you also agree with the notion that if any of the joint venturers, HES or CNOC, were to actually engage in operation type activities, that would be contrary to the law?
We believe so, Your Honor. They would have to, we believe they would either have to get another permit, or there is also, they may join ESSO on the permit after adequate application to the agency and subject to whatever scrutiny and environmental precautions the agency wished to impose. Indeed, Section 13.2 would say that they would have, the agency would examine them to make sure that they could comply with the conditions of the permit. And if not, there are always my learned colleagues who would be waiting there with judicial review to arrest any untoward forward movement. I won't call it progress.
Mr. Pollard, just as a matter of interest, why would ESSO and CNOC want petroleum production license? Why would they need them, given your description of their role in the project?
Your Honor, because they will securitize the license issued to them. They are financial partners. The ESSO, as a developer, will spread the risk and farm out interests in the project. And they are required to contribute a certain amount of financing. Now, they will have to secure these by institutional means because they are not likely to sell equity. And institutional financiers will require that they see that they have rights on their license in order to lend them the magnitude of money that is involved in projects such as these, petroleum production projects, the financiers wish to be completely certain that they have the rights that they say they have.
But why wouldn't a contract between these two entities and SO be enough to securitize, as you describe it, transactions with other financiers?
Because it appears to be one of the peculiarities of the financing of the industry. But I believe it is a widespread industry practice and industry financing practice that the persons, the borrowers, are expected to be licensees in themselves, even though they do not take any part in petroleum operations.
Thank you.
Yes, is that it, Mr. Pollard?
Yes, Your Honors, unless you wish to hear me on any other aspect.
No. Thank you very much.
Grateful to Your Honors.
Yes, thank you very much. Yes, Mr. Datterman.
Good afternoon, Your Honors. Your Honors, the appeal and the contents of it have been well ventilated. But if, from the purpose or from the point of view of the Environmental Protection Agency, I may just put in simple context what it is. The complaint appears to be, in simple terms, and I hope it's not an oversimplification, that when the minister issued a license, he did so, or he needed to do so, on the basis of an environmental authorization having been issued before. So there are two steps. For simplicity, if we take it to be a Part A followed by a Part B. So there must be an environmental authorization in place before, followed by a license. There is no dispute, I believe, Your Honors, that in this particular instance, the environmental authorization was the permit. So there had to have been a permit. The entity that applied for as developer under the law, under Section 10, they were a developer, and the authorization which was sought and granted in accordance with Section 14 of the Environmental Protection Act was to Exxon, ESSO. The minister, there was then a petroleum agreement, and then there was, of course, the license. Both of those documents identify ESSO as the operator. Learned senior before me has gone through what the evidence in this court is from both courts as to what the role of the operator was. So the Environmental Protection Agency is a regulator. Upon issuing the environmental authorization, the role of the agency doesn't come to an end. That would be unthinkable. The role of the agency is set out in Section 4 of the Act, and it involves a number of things, one of which is to give consideration to any activity that may have an effect on the environment. So the environmental authorization that is given to ESSO is issued because ESO has submitted and complied with the requirements. And but when I say the requirements, it may be better to phrase it as the needs or the wants of the agency. So that has been done. There is no risk to say that if you are, or if the environment, the permit isn't being breached. There is no evidence of that in the court, even in the courts below or in this court.
But Mr. Datadin, is it not that the documentation goes further? I recall seeing where in the permit itself, it is set out that if you breach this license, if you violate, these are the things which can happen to you, the entity given the permit. So breach of the conditions of the permit render you, the holder of the permit, the operator, subject to having this permit cancelled, suspended, whatever. Is that not the case?
Yes, Your Honor, I was going to say that Your Honor stole my thunder, but you have, of
very
course,
sorry.
expressed it much better than I could have. But, Your Honor, permits are considered in two ways: contractual, but they're also a sort of subsidiary legislation. They're recognized as such. They're issued pursuant to a statutory provision. There are consequences if the permit holder does not follow the procedure as required. Then, as Your Honor has rightly said, there are consequences. Consequences that range from mild to very drastic. Notice to suspension, and then, of course, the permit is terminated. But, so, Your Honor, from a regulator's point of view, what is being said, or if I am to understand the submission really is about hypotheticals. What if the other two companies are or were to be made operator? What was to happen if they did it without notifying anyone? There are consequences, Your Honor, if that were to take place. To have anyone else proceed in that way, it would be a breach of the permit itself to the EPA. The EPA is not powerless. The statutory provisions that exist allows the EPA to act.
Sorry, have you been pointed to that provision in the environmental permit, which says that the undertaking of operational matters by another member constitutes a breach of the environmental permit?
No, Your Honor, it doesn't stipulate, but, Your Honor, the regulations have a clear regulation 21, for example, Your Honor, has a clear regime of assigning powers or transferring. So you can assign the permit or transfer the permit. Your Honor, if there is a situation where it is happening, if I understand Your Honor correctly, where it is happening without the formal part being followed, Your Honor, there is no requirement that that be stated in the permit. The overarching power of the agency of regulating conduct would mean that the agency can act.
Yes, but can act against whom?
Against the permit holder. And you don't, respectfully, Your Honor, it is not necessary that the Environmental Protection Agency does not require a permit to act against someone doing damage to the environment.
No, sir. No, we agree on that. And I thought we all agreed on all sides that if another member of the consortium conducted operational activities, that member will be breaching the laws of a criminal sanction.
Yes,
could be applicable. No difficulty. In responding to my brother, I thought you were saying that would also constitute a breach of the permit given to ESO. And that is where I wanted you to locate me. Where in the permit will that mean that there's a breach by ESO?
Your Honor, the specific provision is, forgive me, it's a little further. The part that says they're the operator, I think it's H, 2H. The minister hereby, no, this is the license. Your Honor, 1 minute, if I may. But Your Honor, so in the regime that exists, if we're to take the position of the EPA as regulator, the EPA as regulator has the overarching for everything. There could be no complaint, or there could be no insecurity, for want of a better word, on the part of the EPA of having received from ESO in their application, having gone through the EIAs and the necessary documentation, and then issuing the authorization. And then, so the authorization that is required in Section 14 of the Environmental Protection Act exists. The minister then acts. And the minister acts by making the entity that has complied with the requirements in A, if we're to call it that,
Operator.
to be the operator. And they are the be-all and end-all of it in terms of the operation. So as far as the agency is concerned, and as far as the minister is concerned, the compliance with the legislation for the issuance of, firstly, the authorization, and secondly, the license, have been fulfilled. Your Honor, it is, and respectfully, Your Honor, it is dangerous that we go down a path of the what-ifs, because a regulatory agency must deal with what's before it. You wouldn't ask someone to look, an umpire in a cricket match, to look at the VAR for the offside, or improve the rules for offside in cricket. It wouldn't make sense. What has to happen is every individual that requires or wishes to conduct the operations must go through the process. Now, Your Honor, there is, because the Environmental Protection Agency is a statutory body with powers, there would be, if someone else wants to be an operator, a process that must be fulfilled. Now, that process could, whether it would involve doing a new environmental impact assessment and other things, Your Honor, would depend on the circumstances and the situation that is going on. It may be required, it may not be required. And as the court earlier, when Senior Counsel Mr. Loku, that is available, the review is available in certain circumstances for that. But what is the regulator, the EPA, to do? The EPA must take what a company or an entity has come to it with to say, this is the project. This is how we propose to do the project. This is the technology to be employed in using the project. The Environmental Protection Agency, upon being satisfied, said, yes, we give you a permit. So, Your Honor, it is respectfully, I don't want to say a non-issue, but it is not an issue as long as the project is in place, and if the scheme of the legislation really speaks of project, environmental, the act in 14 that mentions about a matter, there is a comparative environmental, in 17 of the regulations, that says it must be for each project for which it is done. So there's no dispute that it relates to a project.
But wouldn't you say it relates to both? Both the developer and the project? Because I went to the trouble of counting a number of times that these terms are referenced.
Your Honor,
Yes,
you
I know we have a
and
long-
I both wasted
we have a
quite a
long
bit of
history.
time.
Yeah, I know.
And if you're not as computer, I am not
Indeed, it
very
could
good
take-
at it,
it
so it
could
could
take
be a
longer.
long process.
But there are 24 references to project,
Yes, sir.
and there are 15 references to developer.
I didn't count developer, I counted
I counted
project. But
So my point is, and I think this was made before, that it's hard to look at approval to the project in isolation from the person who's applying for the approval of the project, who is a developer. So would you not agree then that the authorization applies to both the developer and to the project?
Well, Your Honor, to some extent, there must be overlap because the person coming with the project has got to tell you, well, we intend to use this piece
Exactly.
of machinery.
Exactly.
And we intend to do this with the wastewater or the whatever effluent comes out. They have to tell you this is the technology we will use. This is the approved technology in the industry. This is the impact it will have, whether it will have.
Exactly.
So
and
it has to be.
all we are debating about, therefore, is that if you then change the developer from the one who applied
Yes, sir.
to somebody else, then there are consequences
Well-
in the criminal law and in other aspects of the regime in Guyana. Wouldn't you agree that that's
Yes, Your Honor, and we have to go to Regulation 21 that says if you want to transfer or assign, these are the things that must take place.
Yes.
So in the absence of that, the existence of that foundation, then respectfully the issue doesn't arise, Your Honor. And the actions of the minister or the agency in terms of what has happened and what has gone on doesn't arise. Your Honor, I believe if I wasn't...
But I think that the intention was to not just give a decision in relation to the facts of this case,
Yes, Your Honor.
but to give some guidance as to what maybe...
Your Honor, the Environmental Protection Agency would dearly welcome that. Miss Senior Counsel for the appellants have had the agency.
Occupied?
That would be a polite word, Your Honor. Ragged, closer to that. But Your Honor, that would always be helpful because, as the court well knows, environmental matters have not reached these doors before, and it's always useful to the agency and to the public to have some idea of the interpretations that may go in relation to what goes on. So, but
Can we bear those utterances in mind when we are considering the matter of cost? If Mr. Jairam does not
Your
fare
Honor,
as well as he wishes,
respectfully, Your Honor, my issue is very similar. I am the amicus party. I wouldn't be entitled to in any event. The court politely wrote to us and we agreed. So none of the combatants, if we put it that way, Your Honor, have brought us here. So as it relates to that issue, we stand to benefit in no way.
so you will not get cost, nor receive cost. That's what you're thinking?
Indeed, Your Honor, I have done just a little bit of checking about amicus
Okay.
and amicus party, and I think that's why the court politely asked if we would be willing. And
Okay.
upon
Thank
saying
you.
yes,
Yes.
I believe we are in that boat.
Anyway, it was a kind statement for you to make. Go ahead.
So, Your Honor, if we could just deal with just one, two other small issues, Your Honor. Whether or not the balance is on the entity or the project, and what is looked for. Your Honor, if we start with section 41G of the Act, it says one of the functions of the agency is to ensure any development activity which may cause an adverse effect on the natural environment be assessed before such activity is commenced, and such adverse effect taken into account in deciding whether or not such activity should be authorized. Now, that is a function of the agency per statute, and that would be section 41G. We then have, Your Honor, section 14. Well, before we get to 14, Your Honor, is if we were to look at 11. 11.1a, any developer of a project listed in the foreschedule, or any other project which may significantly affect the environment shall apply for an environmental permit. The context of project is defined as we've gone through, with section 10 being construction works, etc. And developer is also defined in the same section 10 to say essentially it would be the person who's making the application. But if we go to 14, 14 says in very clear terms that a public authority shall not give developmental consent. If we go back to the A and B that I started with, development consent is the B portion of it. So you can't get it where an environmental authorization is required unless such authorization has been given. The environmental authorization lies with the EPA. And then if we look at environmental authorization under 17.2b of the regulations 17.2b say an application for an environmental authorization shall be in respect of one project. So each authorization is for one project. So the scheme, the legislative scheme of the Act is about what are you doing in relation to the environment. Now, the reason why of itself, it means you can start with company A and have company B is because that authorization that can be transferred or assigned. There is a mechanism for it to happen. But the essential part would have to be what guides the minister, because he has to exercise his authority only if there is such an authorization. And the authorization in both the courts below have been reasoned to be the project. So upon the project being permitted, the minister can act. He will then have to determine to whom will he give his consent. Now, he would give his consent to it must, and it should include he who said he would do it. But there is no preclusion anywhere in the legislation or the regulations to say along with that person there can't be others. Now, in this particular circumstances, without getting too much to the hypothetical, Your Honor, this clearly states that the entity, SO, that obtained the permit is the operator, the alpha and omega of it all. And they are named in the permit.
So
Counsel,
the
sir.
I'm sorry, please.
Sorry, Counsel. Could you help me to understand how Section 5 of the EPA affects anything you're saying? Because you seem to be saying that the minister has very large powers, but Section 5 seems to cut down on that.
Well, Your Honor, Section 5 says that whatever powers are exercised that any other public authority, including a minister, would exercise would, of course, be subject to the Environmental Protection Act. But respectfully, Your Honor, the Environmental Protection Act role is in, if we go back, in Part A. Once Part A is completed, the minister's role in Part B is unaffected. He exercises the second limb once Part A has been fulfilled.
Yes, where I'm having a problem, Counsel, is in relation to Hess and C.
Yeah.
They have not been given an environmental permit, but yet they're given a PPL.
Your Honor,
Sorry, I'm just explaining to you my difficulty. I'm
Yeah.
not saying I should have it, but I have it. How does the minister, without the agency granting a permit, how does the minister, how is he able to give the PPL to Hess and to Sino?
respectfully, Your Honor, the short answer would be he's given a license that includes Hess and Sino, but they're not doing anything. So if the role to be played by Hess and Sino were different, then respectfully, Your Honor, different considerations may apply. But he has not given the power by his license for them to do anything other than to be named on the permit, the license. The role of operator goes to the person, the entity, the company, not the person, Your Honor, that fulfilled the requirements there. So respectfully, Your Honor, again, if we get to the hypothetical, it will get problematic, but the terms of the documentation here.
So you have to go back to Section 10.
Yes, Your Honor.
And the definition of project.
Yes.
And it doesn't appear to me that Hess or Sino can satisfy the requirements of 10 to get
Yeah.
environmental permit. Am I right in believing that?
Well, Your Honor, the application for a permit, which will go to the EPA, will be expected to meet certain requirements.
It would have to be in respect of a project.
Yes, Your Honor.
And as defined in Section 10, it doesn't look as though there would be operators and therefore they couldn't apply for a permit, could they?
Well, Your Honor, it would be whether they meet the threshold, but the simple answer would be if we take them to be simply financiers, as we were saying earlier today, and they would simply be financiers of the project.
So they couldn't apply.
Well, Your Honor, everybody could apply. I would go back to the...
But when we mean sensibly apply.
Yes. Your Honor, I would say that if they're not going to be doing the activity, then, or they're not involved in actually doing the activity, then they would not be, they would not meet the requirements.
Yeah, so what is bothering me, and perhaps it shouldn't bother me, but it's bothering me. What is bothering me is that you can't get that environmental permit, but by another, I almost used the word contraption, but that's not the language which I want to use. By another device, you are permitted to get PPL, petroleum production license. You're permitted to get that. How? I'm having difficulty bridging that gap, and perhaps I should, but I am. If you could help me.
Your Honor, if I could respectfully submit to the court, licensing in all its forms have conditions. So some people get a permit to carry a cannon and some get permission to carry a knife. It's a sliding scale depending on the license. Now,
That doesn't apply here, it seems to me. Given the definition of project in section 10, there's no opportunity for a knife or an axe, as I understand it. Am I wrong?
but Your Honor, the fourth schedule of the Act provides in it a list of things in addition to what is in the definition. Now, I would humbly submit, at least by my reading, that financing, or as a financier, is not covered either in the fourth schedule or in the definition of project.
So I should have a problem then?
But Your Honor, again, the environmental authorization is to permit the minister to act and issue a permit in the terms and in his discretion. And if we're talking respectfully about a project that has received an environmental authorization, then the thread that goes through it would be that all that is required for is to enable the minister to exercise his statutory power. Now, who he issues it to and who he limits, delimits, whatever it to, then that is a matter of his discretion, which is, of course, reviewable. That's why we're here. But in the exercise of the discretion, he has limited what the ability of the two, Hess and CNOC. He has limited those two from doing anything. Now, all that the trigger is required of section 15, respectfully, Your Honor, is to entitle him to act. So the question would be, was there an environmental authorization in place to permit the action of the minister? Respectfully, Your Honor, the answer is yes.
So, if I understand you correctly, an environmental PPL may only be issued to co-venturers if at least one of them has a permit, and if the venture is to carry out that which the permit authorized.
Your Honor, that is my humble opinion. I hope it doesn't seem too outlandish. But one is, and that's why, Your Honor, if we take it to be the Part A and the Part B, is Part A fulfilled, then Part B arises. Now, how do you exercise your power with the Part B part? If you are to go, respectfully, Your Honor, if the Part A has been granted, so there's a permit for the whatever the project is, and Part B comes upon the minister and he decides, well, he'll issue it to an entirely unknown entity, an entity that has provided no EIA, there is no involvement of that entity, there is nothing. Then, Your Honor, when we come here, it would be 5 minutes. It wouldn't be 75 minutes each.
And further, the reason why co-venturers may even not be in a position to successfully apply for a permit is because their role in the venture is not one which is normally granted or which is grantable to someone who is exercising that role.
Yes, indeed.
But it is important that they be on a license because the role that they play cannot be effectively played unless they have a license.
Yes. Your Honor, as respectfully, it was said earlier in the court that why do you have to be on a license versus a contract or anything? But Your Honor, if you go for a mortgage, the bank asks you for a title deed. Your father could have given you the house and the whole world knows. The bank's not going to take a chance on that. The bank wants to see a title deed. The industry, these are documents and instruments of trade. When they're issued, they finance the operations that would go on. So that's why that is required. But, Your Honor, the discretion, which is the subject, would be, did the minister exercise his discretion improperly? Respectfully, Your Honor, the minister exercised his discretion to take the entity that had said, this is how we will do it. And, Your Honor, we have to bear in mind, in this industry, especially, intellectual property rights are prime. How you do, what you do, and the equipment you use, everybody is trying to develop the better, or the improved one, or the quicker, or whatever else it is. It's like car racing. Everybody wants a better engine. But it's the same thing, Your Honor. So the discretion that is exercised in this case by the minister is to issue a license. Co-venturers are included in the license, but he said, you put forward the plans, you did the process with the regulator, you're the only person that can do anything here.
I find this very interesting, and I'm sure I'm not alone either, but both your speech and that of those who came before you. And I just wondered whether had the first instance judge and perhaps the Court of Appeal had the benefit of these extensive arguments, if that might not have been helpful. But that's aside. I just want to clarify and what my brother Justice Burgess asked, and the President actually preempted the questions I had in mind. But just one small point. I gather you're saying that the minister's granting of the PPL and the lawfulness, legitimacy of that has to be judged at a particular point in time.
Yes, sir.
And that point in time is when he grants it.
Yes.
Okay? And it's not at large, because as we heard earlier, he has to grant it in the case of a joint venture, to the joint venture where the operator or the developer has sought and obtained
Yes, sir.
an environmental permit.
Indeed.
Yes? But the mere fact that the minister has done this and everything is fine does not mean that if there is a development later on, that earlier grant remains valid. It may be invalidated, wrong word, it may turn out to be not operative if there are changes. For example, in the operator,
Yes, sir.
and the environmental agency has not, for example, transferred
Yes, sir.
the EP to the new operator and so on. So the point then is that the grant may be legitimate and valid at the point at which it was granted,
Indeed.
but there are subsequent events which could operate to, wrong word, but invalidate the grant.
Indeed, Your Honor. And the minister, like the Environmental Protection Agency, it's not you grant it and you're done.
Yeah.
The supervisory role that is played by the EPA to monitor what their statutory obligations is still a continuing one with the minister, and pursuant to what he has granted. he has the right to police and to investigate so it's not, it's done and then it's gone. If they're moving it, the license says this is the operator and the operator is changing. They would have to be, surely, the minister is then entitled to say, well, look, I gave you permission to do A, now we're on to C, and I don't like this, so the role must...
Mr. Datadin, doesn't it go a bit further than that? Is it not the case that what the minister authorizes is for the licensees to conduct, to benefit from the activity in relation to the project, but to operate within the project area? The permit is what enables the actual operation to take place. So that if you have this joint venture of 3 entities, 3 of them hold the license in relation to that project, 1 of them holds the permit, and that one ceases to exist, for instance, so that as a matter of law, it is no longer functioning, and it can therefore no longer be the operator. The existence of the license, it seems to me, does not enable anybody to have any operation taking place in that project area. The license exists, but it is ineffective in terms of there being any production, because the one entity which can see physically to the production has ceased to exist. So the permit continues to be effective, to be valid in relation to the operator only, although the benefit of the license, the benefit of the operator having that permit, redounds to all 3 joint venturers.
Yes, Your Honor,
not correct?
It would likely extend respectfully.
Okay, thanks.
Yes, is that it?
Unless I could be of further help.
Yeah.
Your Honor, I couldn't leave here today without saying the wit of the wit is missed.
Yes, we all miss that wit.
We used to say, Your Honor, there's never been a judge more aptly named.
And they probably won't be. Yes.
I thank you.
Yes, thank you. Mr. Jairam? Yes.
Sorry, there will be a dual response, Mr. Jairam? Yes. Good heavens. How absolutely novel. But on your part? Oh, I see, sorry. I see. There we go. All right.
Yes, Ms. Janky?
I wouldn't allow this. Me.
Good afternoon, Your Honours, and with your permission, I will just address you very briefly on a very narrow issue, which is Section 14 and some of the implications of that section. Section 14, as you know, says that a public authority shall not give development consent in any matter where an environmental authorization is required, unless such authorization has been issued, and any development consent shall be subject to the terms of the environmental authorization issued by the agency. And a development consent is the consent which entitles the developer to proceed with the project. So the Act is here addressing the entitlement of the holder of that of the development consent to proceed with the project. The Act is not concerned with whether or not you operate. The Act merely says that if you are entitled to proceed with that development consent, then you must have the environmental authorization. Now, we've heard much that the other 2 on the petroleum production license are not carrying out their operations. And this may be a concern for the minister because under the petroleum production license, they are required to carry out that license. They are defined, all three of them. There isn't a joint venture. There are three
All
separate
three of
companies.
them.
I beg your pardon?
And when you say all three of them, and the obligations joint and several, such
Well,
that if they can be performed by one, then it absolves the other two from performing it. You wouldn't need the same single thing to be done 3 times over.
Absolutely correct, Your Honor. You wouldn't need the thing to be done 3 times over, but under the petroleum production license, the licensee, which is all three of them, has duties, and all three of them are required to carry out the operations under the petroleum production license.
All three of them are required concurrently, simultaneously, whatever, to be all three doing the same act?
All three of them are required under the petroleum production licensee to carry out obligations under the license.
No, I understand that.
They may be
Uh-huh.
done by one,
Uh-huh.
or they may be done by two,
Right.
or they may be done by
Okay.
three. But there is a legal obligation
Right.
so that if one doesn't do it, or another one must. But to come back to the definition of the development consent, it merely says that the entitlement to do something is what is prohibited. The minister may not entitle anyone to carry out petroleum operations, whether they do or not, because they do not have that environmental authorization. And the petroleum production license does, in fact, authorize all three of these companies, not a joint venture. The minister makes it absolutely clear that he issued a license to 3 separate companies, and that is at page 132 of the record, but I won't trouble you with going there. And some of the things that they are authorized to do is to carry on prospecting and production operations in the production area, sell or dispose of petroleum recovered, carry on other operations that are necessary, and execute relevant works. And that is at page 943 of the record. So the Environmental Protection Act doesn't care whether you are operating. It doesn't care whether you are a financer. All it cares about is to prevent a situation where a minister or other public authority can authorize someone to do something for which they do not have an environmental
But
permit.
Mr. Kapin, what the minister has done here is to authorize a joint venture to do some things.
Or the 3 entities,
With respect, Your Honor,
3 licensees.
there is no evidence before the court of a joint venture. There is merely a definition in the license of defining them or calling them the joint venture licensees. They could just as well have called them oranges and lemons. I mean, it's simply a definition in the petroleum production license. But
So there's a big difference between treating that single license as if it is what it is, a single license, or 3 distinct, separate licenses. Which of the two is it?
it is one license issued
Granted
to
to
3
3 parties.
individual companies
Right.
who are then subsequently defined as joint venture licensees.
And therefore, the obligations in that license may be carried out by one of the 3, by 2 of the 3, or by all 3, as long as those obligations are carried out.
Exactly, Your Honor.
Right.
And the problem is that each one of them is entitled to do it, whereas Section 14 says you must have the environmental authorization as the developer before you can obtain the development consent, which entitles you to do that.
Okay.
So
I understand the point. So there is a risk that CNOC and Hess can say, well, we have this license, so we can do and we will do what what SO alone is capable of and got a permit to do. But if they did that, they would be in breach of the law, wouldn't they?
Yes, they would, Your Honor, but that doesn't take us very much further because we still have the breach of Section 14 by which the minister has granted a development consent which entitles them to do it, whether they do it or not.
He has granted the joint venture, he has granted the three of them the permission to undertake the obligations which are contained in the license, so that if any of them were to, and the evidence that we have that it is only ESO that has the wherewithal and the intention to perform the obligations with which you are concerned. And as long as ESO does this, what is the problem?
Your Honor, the Act doesn't say that he may grant it to people who are not doing it, even though they are authorized to do it. The Act says that the development consent entitles them to do it. The mere fact that Hess is entitled to carry out obligations under the joint venture, under the petroleum production license is sufficient. The mere fact that CNOC is entitled to carry out activities under the license is sufficient.
Well,
Sorry, sufficient for what? Sufficient for what?
Is sufficient to be in breach of Section 14, because the Act is only concerned with their entitlement, which is granted in the development consent, and which therefore allows them to do these actions. Whether they do it or not, Section 14 is not concerned with that. Section 14 is concerned to stop a situation where people may be authorized to carry out activities that are not authorized by and governed by and restricted by and subject to conditions.
Counsel, I have to
governed by-
jump in here and tell you that that interpretation, if it is an available interpretation of Section 14, to my mind would have to yield to the basic proposition that the law is not to be interpreted as facilitating the commission of an offense or a wrongdoing. So if there is another law which says, however, that this may be done only by this person, a person who holds a permit, then Section 14 has to be interpreted as the minister has interpreted it, which is that you may all three hold this one license, but I know, you all know, that only one of you can do the things which the permit in relation to this license.
Thank you, Your Honor, but that's not what the license says.
Well, then that's how you interpret
The
the
license says that they all three are authorized and entitled to
Right.
do these things. And in terms of
Anyway.
the law, if we know that it would be a criminal offense for Hess or CNOC to carry out operations under the license, but that does not actually address the problem that Section 14 is intending to address.
Sorry, Counsel, sorry. Does joint venture have any legal status apart from the fact that it is a contractual status? Is there a legal entity called a joint venture? I know of a company, I know of an individual and so on, but does a joint venture, does it have any legal status, any legal personality?
Most assuredly, Your Honor, it can. But in this case, there is no separate joint venture company in which the three, SOS and CNOC, have shares. What they have said is that there is a joint venture arrangement, but there is no evidence that this is a separate legal entity. There are three separate companies who have some kind of arrangement, which is not in evidence before the court, so we don't know what that arrangement is. All we know is that the minister has issued a license to three individual companies, and that he has said that that is what he has done, three separate companies.
Ms. Janki, can I take it another way from what you're saying? Because we had several discussions with your colleagues on this sort of issue. So you're saying then that Hess and CNOC in the circumstances of this case, no hypotheticals, ought to have and were entitled to go to the Environmental Protection Agency and to seek an environmental permit, even though they were not operators and were not carrying out any operations?
What I'm saying, Your Honor, is that if Hess and CNOC wish to have the benefit of a petroleum production license, in order to obtain that license, which authorizes them, whether they do it or not, to carry out petroleum operations, then they must first obtain an environmental permit. They must go through the process of obtaining an environmental permit in order to be eligible for a petroleum production license.
But if they're not carrying out any operations, why are they to get an environmental permit? That is what I'm trying to follow with you.
Because the purpose of the provision is to prevent a situation where a person can be authorized. It is to remove the risk that someone may then take that petroleum production license and actually do something that they are authorized to do under the license, but not authorized to do because they don't have a permit.
But
The
would you,
permit is a precondition or a prerequisite to the grant of the petroleum production license.
but would you agree though that the license granted by the minister cannot override the environmental permit?
The license cannot override the environmental permit, and thank you, Your Honor, for bringing me to that point, because Section 14 also says that the development consent granted by the public authority shall be subject to the terms of the environmental authorization issued by the agency. And the key term of the environmental authorization issued by the agency, the environmental permit, is that it is issued to ESSO Exploration and Production Guyana Limited, and that it authorizes ESSO and nobody else to carry out the LISA 1 project,
Precisely.
which is the project before us.
But Counsel, that's precisely my point.
So the license cannot authorize, it cannot go beyond the permit. It must comply with it is subject to the terms of the authorization. One term of the environmental authorization is that it is issued to ESSO and ESSO only, and that is a key term.
And that is the point I wish to make, that the license granted by the minister cannot override the terms of the environmental authorization. The environmental authorization authorizes ESSO to conduct certain activities in relation to the project.
Yes.
So I understand your interest and concern for the environment, but the truth is that the license granted by the minister is not going to affect you adversely, because when he grants the license to the three entities, that grant cannot override the environmental authorization, which says that ESSO is the one and the only one who can conduct activities in the project that could affect the environment. So I'm trying to understand your concern.
So the minister cannot grant a license to Hess and CNOC because he cannot go beyond the terms of the environmental permit, which is granted only to ESSO. So he's subject to the environmental permit. He looks at the environmental permit, he looks at the terms and conditions, the key condition of which for the purpose of
Well, I think it's a way that you,
of the permit.
with respect, Counsel, I think it's the way you put it, because the way it reads naturally is that the license granted by the minister is subject to the environmental authorization. The environmental authorization says that only ESSO can conduct operational activities. And therefore, I am trying to understand the concern you have.
Tell me something. Was the permit, and I'd like to use the same term right through. So when I say permit, I mean the environmental permit. When I say license, I mean the PP. Was the permit issued pursuant to the agreement?
No, Your Honor.
No.
The permit is issued by the Environmental Protection Agency in accordance with the Environmental Protection Act.
Was there an agreement that was signed before the permit was issued?
There is a petroleum agreement between CNOC Hess and ESSO.
Was it
Government
signed
and-
before the permit was issued?
Yes, it was signed in June
Did the permit-
2016.
Did the permit make any reference to the agreement?
No, it does not.
It doesn't.
No, it is an entirely separate statutory regime.
Okay, fair enough.
Which is designed to ensure that no one without a permit can carry out activities under a development consent.
So I'd like to summarize as succinctly as possible the submissions so that I could assess them. Am I correct in saying your submission is that a permit is a precondition to the grant of a PPL, and the permit holder may not seek, and the minister cannot grant a PPL to co-venturers who do not themselves hold a permit in their individual capacities? That's your submission.
Not entirely, Your Honor. If I may rephrase it, the submission is that only ESSO, that a permit holder may apply for development consent, in this case, a petroleum production license. Anyone who does not have that environmental permit is not entitled to apply for a petroleum production license or to
yeah,
obtain it.
that's exactly what I've captured.
But whether they are co-venturers, I have no idea. Whether
Fine.
they are,
So the permit is the precondition to the grant of a PPL.
Yes,
If you
it is.
don't have a permit, you cannot have a PPL issued to you.
yes, that is correct, Your Honor, and that is also a submission that has been advanced by the respondent. I think it is at page 800 of the record, at paragraph 32 of his submissions, and it is also been endorsed by the Chief Justice, where she says that.
This is a paragraph 36.
No, Your Honor, but I will come to that. It is, I think it is page 531 of the record where the Chief Justice refers to section 5 and says that the minister is the person who must have seen that there was already an environmental permit. My learned friend's case has turned on the argument that while this is indeed a prerequisite, a precondition, that it is met by the argument, they say, that the permit is only for a project, and that by having a permit which covers the project, that the condition in that section 14 is satisfied. I will not address those arguments, Your Honor, because we've done so extensively in our submissions that the permit is granted and personal to the person, to the permit holder. I would like to, with your permission, just refer now briefly to the Court of Appeal decision, which was found this morning, and which at paragraph 36, the court, it says this court finds favor with the submissions of Mr. Luku SC. Mr. Luku has pointed out that he does not agree entirely with the wording of paragraph 36, which says, section 14.1 makes it undoubtedly clear that the process of issuing a license pursuant to the Petroleum Exploration and Production Act is predicated on a licensee obtaining an environmental authorization or permit. Well, the licensee in this case is anyone that is holding the license. The licensee is the holder of the petroleum production license, and in this case, it is all three of them. Your Honor, I would just like to touch briefly on this idea of the securitization, which is a matter that deals with the financial arrangements of ESSO, Hess, and CNOC, and has no bearing whatsoever on the Environmental Protection Act. The purpose of the Environmental Protection Act is to protect the environment and the people of Guyana, and the risks of this operation are quite clear. If I may draw your attention, for example, to RG 21, which is attached to Raymond Gaskin's affidavit, which is the map which shows the potential expanse of an oil spill. The purpose of the Act is to protect the environment, and it does so in two ways. One is by the requirement for a permit and by the regime of continuing control within that permit. And to say, for example, that, well, if they commit a criminal, if they do this illegally, there is a criminal offense and that can be dealt with that way, does not entirely answer the question, because we have the avoidance principle in Section 4 of the Environmental Protection Act, which says that it is better to avoid damage to the environment. And the way we avoid damage to the environment is precisely by the regime that is set out in Part 4 of the Act, which requires an environmental permit.
Yeah, but Ms. Janke, if we agreed with your submissions and deleted Hess and CNOC from the license, would the risks in relation to environmental harm be diminished? Would the risks to environmental harm be diminished by the deletion of CNOC and Hess from the license?
Yes, I think they would, Your Honor, because as long as there is the possibility that two other companies can carry out operations.
They cannot lawfully.
They cannot lawfully, but, Your Honor, unlawful things have been known to happen by anyone. They are not exempt from, I mean, they may do so unwittingly, they may do
Counsel,
so...
forgive me.
Yes, Your Honor.
Well, it seems to me that the essence of your submission is that the existence of this license in the hands of these two entities is a dangerous thing in itself.
Your Honor, I would say that, I would phrase it slightly differently and say that this is what the Environmental Protection Act says, because it seeks to avoid a situation where someone who does not have a permit is entitled.
That is your phrasing, but I am just trying to get it clear in my own head. And would you see my ability to say that based upon what you are saying, that it is dangerous for these two entities who don't have a permit to be holding a license?
Yes, I would
Thank
say
you.
that it is
All right,
dangerous,
that's it.
Your Honor.
Well, I want to tell you that we are fully aware of what you are submitting.
Thank you. And so just to close off, Your Honor, if I may, on the issue of securitization, the financial arrangements for these three companies are their concern. The petroleum production license is not a piece of paper to be taken to the bank. If they wish to make arrangements, then they can make proper arrangements for their finances. But the key issue here is that once they are entitled to carry out operations under the license,
But they're not entitled. If you agree, if you accept that were they to carry out operations, CNOC and Hess, they would be doing so unlawfully, then how can you simultaneously say that the minister has authorized them to carry out those activities?
the Section 14 that says, so the development consent only says that they must not, that they are entitled to. And once they are entitled to, then the minister has breached Section 14, and he has to defer to Section 14. Section 5 of the Environmental Protection Act says so, and Section 17 of the Petroleum Exploration and Production Act also says so.
Okay, so
He must
I
defer.
cannot derail you. Let's get to the securitization issue. Is the court to be completely oblivious to industry-wide practices in relation to this issue?
Your Honor, industry-wide practices must be subject to the statutory regime imposed by the laws of Guyana. And these laws are intended not only to protect Guyana, but also to protect the Caribbean, which is why I drew your attention to the exhibit RG21, which shows the potential harm to the Caribbean. I fully understand the need, the financial arrangements. I myself worked in the oil industry, and I understand the need for these operators, for these companies to have something to go to the bank with. But if in that case, it must be something that is lawful. something that is clearly within the parameters of the Act or something that is not caught by the Act. They can give a parent company guarantee. There are many, many, many other financial instruments that can be created. And both Hess and CNOC are extremely experienced in this, and they can do that. Unless there's anything else, Mrs. Ramon.
Yes, thank you.
I thought, Mr. Jayaram, you'd be gracious and say that after all that, there is hardly anything I can say.
Unless you say the two words gracefully.
I would like to emphasize what my was said. When you look at the definition of the which transform the picture, it is entitlement. And that is the danger we have to guard against. By giving them, whether or not is a practical matter, by giving all free the entitlement to proceed, that means in law, the minister acted incorrectly. In that context, Your Honors, we say Regulation 21 would have been otious had it related to a project alone, as some of my learned friends have submitted. It relates both to the person and the project because it doesn't operate separately. So that because they are in the Act, I pointed to some this morning, the EPA must assess your ability, financial ability, and so on, before you're granted a permit. And the marginal note, while I know it doesn't govern, Benyon has it's a useful tool in interpreting environmental authorization as a precondition to development consent. And Your Honors, all we ask is that you plain language, no strained construction. I think Mr. Justice Burgess has asked repeatedly, and if I may say with respect, I entirely agree with him. Because when you look, Section 10 is short. Developer means the applicant for environmental authorization for a project. Neither has nor CNOC applied. And project, they don't come within the definition of project. And we all know, as a matter of common sense and trained lawyers, where you have a dictionary provision in Act, we can't seek to expand it. And may I say lastly, Your Honor, the citation by my learned friend, Mr. Lockham, of all these authors and so on. While helpful and useful as a guidance, the learning cannot trump the provisions of the Environmental Protection Act. And we say with respect, that is where the minister, we didn't judicially review the APA, no. The minister went wrong because, and we are supported by Section 5 and Section 17. So Your Honor, it's a serious case, and we thank you for engaging all of us.
I wanted, as you're winding down, you know, I wanted you to reflect on the reason why you are here in the first place, which I gather is a genuine concern.
Yes.
For the due administration of the environmental laws in Guyana.
Yes.
And by extension, the protection of the environment, consistent with sustainable development.
Yes.
Okay. And I want you to reflect as well on the, I don't want to say concessions, but the agreements that you have extracted from the other parties in this case. And I want you to think whether those agreements, concessions, if you will, that you have extracted, do not put you in the place that you really want to be. I would say, for example, that we have heard very clearly from the EPA that they have a responsibility for the continuing monitoring, protection of the environment. We know that the environmental permit, the terms, the execution of it are governed by the terms in the permit. So if the permit says, for example, that only SO can conduct operational aspects of the project we're speaking about, then only SO can do that. And I feel that as an environmentalist, that is something that would be of interest perhaps gives you some satisfaction. No other entity can conduct operational aspects of this project. And if another entity sought so to do without the requisite permission, transfer, etc., of the EP, then they are committing a criminal offense. Now, to me, those sound like very, very serious concessions or agreements, I should say, which are consistent with the overall objective that you came to us with this morning. And I'm just wondering whether you might not wish to reflect on that, whatever it is that the final decision of the court is.
Your Honor, I have to be brutally frank
Yes.
and to say, while I'm grateful for the concessions, they do not satisfy the requirements of the Act, which is plain and simple. Before you, Mr. Minister, grant consent, which is the PPL, you have to get an environmental permit. And you know, oil companies, and these are huge oil companies, the names at least, not the paper company, the names. And if there's, God forbid, if there's an oil spill, we see what's happening in Tobago, small oil spill. This has the potential, the map drawn to your Honor's attention.
That matter is covered in the environmental permit, though, is it not?
Huh?
That matter of the liability for spills, that is covered in the environmental permit.
Yes, but it could go very far, up to Jamaica. We know if there's an oil spill in water in the high seas, it is most difficult to contain.
Yes.
And you see, that is why we have to, because this will be a precedent-setting case, not only for Guyana, but for the Caribbean. Suriname is about to develop. Trinidad has had long experience. And so, Your Honor, we say with respect, once you come to the conclusion that the permit is in respect of a person and a project, not a project alone, then, and Regulation 21, if it was a project alone, would have been otious, because you have to assess, as my learned friend Mr. Locke said, the suitability of the transferee or assignee. And if it was a project, you don't have to have a transfer assignee. If it's a project, go ahead and we rely on that Irish case, Your Honor. The Irish case, sorry, both the first instance and the Court of Appeal, that talks about the
Yes, I tried, Mr. Jaram.
well, you have you know, made a good point. I'm not discounting it, Your Honor. But you know, the law is the law.
Of course, yes.
And I will invite your sitting in the position that you are in to uphold the law. The minister went wrong, not the EPA. We have no bone or contention with the EPA. I don't agree with what Mr. That didn't said. Submissions, all of what he said. Because at one stage I was wondering whether he appeared at mic. He seemed to be taking the position of the other two of the respondents and interveners. But I think the essence of the point is, I ask you, in summary, Your Honor, no learning, however enlightening, but trump the simple provisions of the Act. According to your brother, Mr. Justice Burgess, I agree with him. Neither Hess nor Sinop, nor both of them can qualify under Section 10 to be a developer because they haven't applied for an environmental permit. And financing, my lord, sorry, Your Honors, every little law student knows, financing can be supported by other instruments. If your backers want you to have a PPL, then go through the trouble or the process of getting an environmental permit. That's all. We're not asking to move the heavens and heavens to fall for it.
Understood.
Join with SO or do it alone. Simply that. And our case boils down to that. And I was grateful to Your Honor, Mr. Justice Anderson, this morning. We have the precautionary principle and the avoidance principle. And that is the purpose of policing what is environment and the requirement for a permit. And that's how we tie it up with constitutional provision. When you read them, there are threats of serious or irreversible damage, lack of full, etc., and I will take a step avoidance before to avoid environmental damage. You see, one important thing, I know, Mr. Justice Anderson, who harp on the criminal penalty. But the criminal penalty as compared to oil spill is minuscule as an ex post facto. Whereas if the agency grants you a permit, it has continuing to monitor, control, and so on, and it has implied and expressed condition.
May I take objection to the word harp?
I'm sorry.
Yes,
sir.
yes.
withdraw the
I don't sing very well, so
I am so sorry.
yes.
So, Your Honors, I ask you please consider very carefully. I know you have raised genuine concerns, but look at the case in the round and what the parties are saying.
Yes, thank you very much, Mr. Jairam.
Very much obliged, and thank you for a patient hearing. All of us.
Thank you. And thank you to all the other counsel for your submissions. We would reserve our decision and let you know when we are ready with it. I want to say a special thanks to the students from the Hewlin Law School who have been with us throughout the day's proceedings. It's not often that we have an in-person audience of this size for our appeals, and we certainly are grateful that you have found the time to come and to listen to counsel and to the presentation of the case. And we wish you all well in your studies.
Very much obliged.
All rise.